Thank you.
Morning, Mr. Rosario.
Good morning. How are you?
Good, thanks. I'm just waiting for your attorney to log in and then we'll get started, okay?
Sounds good.
How about now?
I can hear you.
Ah, how about that? Okay, good.
Did you get my email?
No.
No. So what I'm gonna do today is, Mr. Rosario, this does not pertain to you, just so you know.
No problem.
I'm going to continue the case on the record and its hearing will be April 8th.
Very good.
Okay?
Thanks so much.
Thank you very much.
Bye-bye.
Bye. And you just have to unmute yourself. Can you hear us?
He might be having the same audio issue as Attorney Maddox.
So what would he, go ahead.
Attorney O'Brien, if you can leave the meeting and just try to rejoin, it doesn't look like we're having any audio from you. So if you just close out of this window and try to join the live event again. Unmuting doesn't do anything at the moment. It's not picking up your microphone.
Oh, he can't hear you? First, you need him to log off and log back on?
Yeah, he is leaving now.
Okay. I think now you could try unmuting.
Yes, ma'am. I hear you
Yeah.
loud. I hear you
Perfect.
loud and clear. I'm sorry.
That's okay. No, we had a problem with the audio, so we are good to go now. I can hear everybody.
Right.
So we're going to get started with the revocation hearing.
Yes, ma'am.
Good morning. I am P.O. Meisinger, hearing examiner for the Board of Paroles and Paroles revocation hearing concerning Rosario-Torres Oscar number 158633. Today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office in the Carl Robinson Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Oscar Rosario-Torres, 158633.
Thank you. You have counsel here today. Can you please identify yourself for the record?
Yes, good morning, Miss Attorney John O'Brien of Manchester on behalf of Mr. Rosario-Torres.
Thank you. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better or weaker evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing you, place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No,
Okay, you
No,
have
ma'am.
important rights today. You have to have an attorney present. You have counsel here. You have a right to receive the written notice of charge of the violation. Did you receive the written notice?
yes,
You have a right to view the evidence against you. You have a right to submit evidence supporting your case. At this hearing, you have a right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
That last part, I haven't seen any evidence, regarding my revocation, you know, with the claims and allegations and charges against me. So, that's where the problem lays, that, you know, I want to
Well, you
see.
received the packet of information from the parole board, correct? That's what I'm asking you, if what you received.
Correct,
So,
yeah.
That's what I was wondering.
That's what probation, you know, that came from probation, not parole. I mean, it was given to parole because parole
Well,
didn't.
it's what we have, it's what we have for your violation.
Correct,
Okay.
correct.
So I'm going to move on. So we now review the charge the state your PO is bringing against you and information underlying each charge. Charge 1 under release direction GPS. You're charging officer reported on 1/12/24. The offender left his residence from 11 p.m. to 11:05 p.m. Offender's curfew was 9 p.m. On 1/17/24, the offender failed to charge GPS unit properly, leading to the GPS unit shutting down from 5:16 p.m. until 5:24 p.m. And on 3/8/24, the offender failed to charge his GPS unit properly, leading to the GPS unit shutting down from 4:44 p.m. till 9:25 p.m. Charge 2 under obey all laws, obedience to the law. You're charging officer reported on 9/27/23, the offender failed to report to sex offender treatment. On 10/3/23 and 10/14/23, the offender failed to report to his probation officer. On 11/29/23, offender was found in possession of an unapproved smartphone. On 12/7/23, the offender was found in possession of an unapproved tablet. On 12/18/23, the offender left the ND Center on a work pass to go to work. The offender's employer was called and there was no work that day. On 2/7/24, discovered the offender had not been attending mental health treatment for 2 months. On 3/8/24, the forensic examination of the offender's phone, which was previously seized, was received showing the offender being in possession of 35 sexually explicit images and using Telegram as well as installing Instagram and TikTok applications. On 5/6/24, after reviewing cell phone data, it was discovered the offender was having a sexual relationship with 3 women, which he failed to disclose to his probation officer. The offender was calling and texting multiple women, attempting to arrange dates and have sexual relations. On 5/28/24, the offender lied to his probation officer regarding the name of the woman he's in a relationship with. Offender was asked more about her residence, and he disclosed that minors visit the residence. Subsequently, on 6/18/24, a warrant for the offender's arrest was signed, charging him with violation of probation. I will put on the record that the addendum reported on January 9, 2025, the offender was convicted of violation of probation, received a sentence of 13 years jail, execution suspended 2 years with 14 years probation to follow. I have an EOS date for that of 6/12/26 at this time on that sentence. And the state has followed the following exhibits that are pre-marked for identification purposes. As Exhibit A, remand to custody. B, parole violation report. C, notice of parole violation. D, conditions of parole. E, misconducts. F, GPS monitoring agreement. G, violation of probation warrant. And H is pending case detail. I will note charge 3 is not taken in consideration. You were not charged with mental health treatment as far as parole goes. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes.
Okay. And do you need to continue sharing to obtain any additional evidence?
I want to see this electronic evidence that they have, these 35 explicit images.
Well,
and I have witnesses.
Listen,
that will
I've
testify.
continued your case like 15 times.
I know.
I understand that you disagree with this. I completely understand. So if you're attorney, do you need
100%.
to obtain any new evidence? Is there a reason why this should be continued?
I do not believe so, ma'am. We're prepared to make argument, and I believe that the state will be unable to produce evidence in support of many of the allegations contained in the charging sheet here.
Okay. And I have no witnesses at this time. So it's now defense opportunity. Mr. Rosario, do you plan on speaking today at all?
If I need to.
I'm gonna swear you in under oath in case you do speak. So if you can just raise your right hand for me, please. You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes.
Okay. So Mr. O'Brien, if you can go forward now with whatever you'd like to say.
All right, thank you. I would respectfully submit, without going into detail, the GPS violations are de minimis. 5 minutes, 8 minutes. These are not cause for a violation of parole, not cause for a violation of probation. The fact that on one occasion he left it uncharged but I would like Mr. Rosario-Torres to address the issues of his mental health treatment and specifically his sex offender treatment and the allegation that he left sex offender treatment without permission or without any authorization from anyone. And I would ask him to explain that to you with respect to his work at the Connections.
Okay.
Mr. Rosario-Torres?
Okay, when I got out and I met Anne Marie Mushhorn in Middletown while I was at the Eddy Center, and I formally met my probation officer for that area, I was told I was going to start that offender treatment at, I believe, 22 Court Street, the Connections, for this offender treatment. I started going. I went to maybe 2 or 3, a handful of sessions where I would go at 2 o'clock, I believe, every Wednesday. And I was reporting, it was once a week. And finally, they knew I had a pending habeas corpus. The director from Connections, along with another coworker, they have records at the Connections that state that Mr. Rosario-Torres was unable to complete or attend their treatment program because I couldn't disclose matters of my case because I have a pending habeas corpus in the GA district of Rockville, Connecticut, with attorney Jason Goddard out of Hartford. They told me I cannot attend. That was reiterated to probation officer Anne Marie Mushhorn, and now after the fact, with all of these allegations, they're throwing that into the mix and saying that I chose not to comply and leave the program of my own accord, which is 100% unequivocally untrue.
And that information was communicated to your probation officer at the time, Anne Marie Mushhorn.
And Kelly DiCaprio afterwards, because she made a big deal about it. Oh, you didn't go to offender treatment. So, and then she went about finding the Sterling Center with Eliza. There's a program in Cromwell. I started that program. I met with Eliza one-on-one, and I was going to that one for several weeks. And that one's at night. And there's records of me going there because my insurance is being billed. If you look at my Husky insurance, you can see that the dates are that it's true that I was going to these places. There's evidence out there to exonerate me on 90% of these charges.
Okay, the thing is, you're being charged with obedience to law and you received a new conviction. So that's what I'm looking at. If you want to explain to me, like exactly like you just did about how you did attend sex offender treatment. Right. Those are the things, I mean, you could say that, but you still were convicted and received that new conviction and with a sentence. So that's what we're looking at. You received a new conviction.
Well, so, I understand, but I also want you to know and take into consideration that with that judge, Judge Pratt's, is that on that conviction, I'm looking to take back that plea for other reasons, because I know that that electronic information on that phone, I didn't install those apps. I didn't download any explicit images. I need to see the evidence. And like I said, you're right. The conviction is there. I did accept it. But like my original case, I'm taking back my plea because I'd rather go to trial and face more time. And when you read off, the charges and everything else, that I accepted a sentence of 13 years. I did 1 year of probation. 1 year should have came off. My lawyer knows about this. So there's all these discrepancies and all these things that I get hit with that are incorrect by the judicial system, the courts or whomever, my supervising officers, and then I have to suffer the ramifications. I did do a year of probation out there. It shouldn't be 13, it should be 12.
Oh, I understand what you're saying completely.
Yeah.
So I am going to give you a chance to talk to the second part of the hearing, which involves the mitigating factors. Do you have anything else you want to say in regards to just those two charges is all I'm looking at right now?
Yeah, ma'am, I was going to treatment. I went to treatment. After that program, I left and I moved to New Britain and I started working in New Britain and I was living there. Once I left the Eddy Center, I went to another. I didn't go to Connections because Connections legal board, their attorneys advised against me attending. I started going to the Sterling Center, who has 2 locations in Connecticut. I was going to the one in Cromwell and I was going there for a while.
Okay.
Okay.
So I never refused, I never,
No, I heard you. I hear you.
Yes, Mr. Rosario-Torres, did your parole officer approve for you to have a tablet?
correct. Officer P.O. Norton, whom I never met face to face, according to the Eddy Center staff, when after the phone issue, because that was my mother's phone. My mother is the one with the Facebook account. That's her phone. I didn't install Facebook. If you go look at that phone right now, log into it, you'll see that that's my mother's phone, Nydia Torres, and that's her Facebook account. I wasn't on Facebook. Okay. I don't want to. Okay, so I wasn't on Facebook.
These are going to be some mitigating factors that we can talk about for the second part of the hearing. Because as I already explained, you already have a conviction for that. So I'm looking at the GPS and I'm looking at the obedience to law charge, which you received a conviction.
Correct.
Okay,
But,
so we can talk about the mitigating factors at the second part of it. Okay.
No, but just to answer his question, yes, I was authorized to have that tablet per the staff at the Eddy Center, period. And they took it and never returned it.
Okay.
At some point in time, Mr. Rosario-Torres, did your Anne-Marie Mushhorn, your probation officer, make contact with the 3 women with whom you were acquainted?
Not Anne-Marie Mushhorn. After it was with Kelly DiCaprio, she made contact with all 3 women in front of me. She called each and every single one as I was in her office. And
each one of those women acknowledged that they were not having a sexual relationship with you. Is that correct?
One out of the 3, you know what? She just inferred that just by the text messages, because I don't know where she got that with Mary, because me and Mary were never intimate. And I don't want to use their full names, but she just inferred that from us getting together to watch movies. That was inferred from the data that was going back and forth through text messages. But
and the 3
those women will
acknowledged...
justify that we did not have sexual relations, and I was not calling them to solicit relationships. These people all knew my record and my checkered past and everything that I've been convicted of, and they still chose to have a relationship with me, to be friends and conduct. These are all people that are over 50 years old. These are not, and I also just to go back to this, Mary never said, and nor did I ever say that minors go to her house. She doesn't even have any grandchildren.
Okay. So we're still getting into mitigating factors. Is there anything else you just want to say for the first part of the hearing?
No, ma'am.
No, ma'am. Thank you.
All right. So what I'm going to do next is I'm just going to announce my findings. So on that charge 1, I do find you violated the condition GPS. This is based on evidence that was provided, which is exhibits D, E, F, and I. And on charge 2, I do find you violated condition obedience to the law based on your conviction of violation of probation, received a sentence of 13 years, execution suspended after 2 years with 14 years probation. This is also based on the exhibits that were provided D, B, and G. So that's the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So at this time, if there's anything in addition you'd like to add, as far as what your release plan would look like, any other mitigating factors that you didn't discuss yet that we've already addressed, you could do that now.
Yes, ma'am. So I would, with respect to mitigation, I would respectfully point out on these findings of the GPS that in and of themselves, they are very minor, both in time, both in the number of violations, 5 minutes, 8 minutes, and then one occasion an uncharged or a depleted battery in that remote. I think with the issue of the treatment and his non-compliance with treatment, I believe that he's accurately answered that question or that issue, addressed that issue by virtue of being told by the connections that due to his seeking relief from that conviction that caused him to have the sex offender treatment, that he could therefore not fully participate if that conviction was going to be reversed or is being contested, and it is being contested in a habeas case. So he did not, in and of himself, walk away from treatment. he was sent to alternative treatment, which he complied with on an individual basis. With respect to the relationships, there never was any proof, any acknowledgement by anyone of being engaged in a relationship with my client at any time outside of just a simple acquaintanceship or friendship. But I believe that Mr. Rosario-Torres is prepared to address his plans for a return to the community and what his situation would be there.
Okay.
But
Go ahead,
Mr.
sir.
Rosario-Torres, upon your
Okay.
release, upon your ultimate release, what are your plans, sir?
To do exactly what I did the first time.
Tell me what that is. Yeah.
That is, a facsimile copy of what I did the first time, and that entails when I got out, I didn't need to go to that halfway house. It was horrible. It was poorly run.
You
I
have a
wish I was
sponsor?
experienced. I do have a sponsor. I have money to have my own apartment. That's what I did the first time. I went to the Eddy Center for, God knows, almost
Well,
6 months.
if you were to discharge right now, do you have sponsor information available for me, or do you need placement in a halfway house before you get your own place?
No, ma'am, I would have my own place. I would have my own job. I have a car, I have a bank
Well, I
account.
can't parole you. Do you own your own residence right now?
I don't, but, I have family.
So you have to go to a sponsor's house, or I would have to parole you to a halfway house. So which would it be?
I would have a sponsor for now, but I mean, it depends on when I get out. I mean, I can have a place like that. My family, they own real estate.
I
so,
can't
like,
parole you out like that, and you'd have to have that right now. So
Just
who is your
specify
sponsor?
who is your sponsor?
Lillian J. Rivera, my sister.
Lillian Rivera?
Yeah, middle initial J's and Juliet.
Do you have the address and phone number?
I have her phone number, 689-250-3714.
You don't know the address? Do you know what town it is?
Well, she resides with my mother, and she also has a place in Middletown. So, so I don't know which of the two addresses she would use. That would be up to her.
All right, so I'd have to put halfway house in there right now because you don't have information for me for sponsor. So what halfway house area would you go to if this does not work? Hartford, Waterbury, New Haven,
New Britain?
New Britain has halfway?
no, Hartford's closest.
Oh, no, not Hartford.
New Haven,
Haven?
Waterbury, Norwich, those are, I mean, Bridgeport,
New Haven?
New Haven?
Yeah, I don't want to go back to Middletown.
Okay, so you can work on getting that sponsor information to me. If you get a re-parole date, work on right to the IPO there, your sponsor information, or your attorney can also email me your sponsor information so that I can update that for you. Okay. Do you have a job, or do you plan on, what does that look like?
I have a job. I was working when I was relocated on 6/18/2024. I worked for Tree Wise Guys,
Okay.
and that's in New Britain at 4 Woodland Street.
You plan on going back there or no?
I plan on going back there.
Is that full-time or part-time?
That is full-time.
Full-time.
Yeah, like 7, 5, I mean, minimum 5 days a week, sometimes 7.
Okay. Any other plans you have when you get released?
I had my CDL before, so I've been studying here, taking advantage of this time. So I've been studying for my CDL, and everywhere I go, since I've been transferred from county to Cheshire to MacDougall to here. So every time you go, they change your offender, your OAP. So everything here is a wait list for programs. It's insane. So it's a wait list. So they've changed the programs that they want me to do. Now they put a 5 to 7 day job and new thoughts. Before it was anger management and something else. I did some of those programs already and have completed them successfully. So I'm really trying to do something here where it's more towards finishing my degree with that Stuntup Community College, but I got waitlisted.
Okay.
So I'm just reading and studying my CDL so I can go back and get that licensure again so I can drive the big trucks at work and make more money.
All right. Is there anything else you want to add before I take a break to make a recommendation?
Just,
From Maddox. Okay.
I mean, based on my charges, based on my original charges, when I go in there to get supervised, just looking back in hindsight, and having the second officer, not Anne Marie Mushhorn, but just hearing what that officer had to say, and I'm not gonna, say it on the record, but it wasn't a good start because of my, because of the kind of charge that I have. I had 2 GPS bracelets on me. I had tracking software on my phone. Everyone with charges like me, when they got to the Eddy Center, they all had phones. I was the only one. I had no crime with a computer or phone or anything. There was no reason for me not to have a phone. They made me wait months to get a phone, months. So I take responsibility for having the phone because it was my mother's, and she's like, here, so you can call me directly. I took the phone. You think I would take my mother's phone and use it for pornographic? I'm not here for that. I didn't do that. Explicit images, porn, whatever it is, if there was no porn. Explicit images, I've never seen them. This evidence was never given to me. And like I said, the GPS violation where I left for 5 minutes, I told the officer, that was the first day I got it, ma'am. And I forgot the charger in the car. I ran across the street. I live across the street from the police department in New Britain. I run across the street, I'm on video. I even got that video from my apartment to show why I went to that car and came back and showed that video on a computer to my PO officer. That was Lisa Brayfield, okay? It was a mistake, but I needed the charger because if not, I wasn't gonna page her or call her at 11 o'clock p.m. I ran and I had 2 heart attacks. I ran and made it across the street and back in 5 minutes. The other time it went off for 4 minutes, that was a glitch on the GPS.
No, I do understand, and your attorney did express that they were 5 minutes. So I do take all that into consideration when I'm going to make a recommendation. Is there anything further before I make a recommendation?
Man,
the
way that warrant read about those women made them sound like they were prostitutes. Like I was calling them, and the way that those supervisors spoke to me said that it made it feel like they were sex workers. The verbiage on there changed from the original time that I was served with the information of the charges against me. Those documents were altered and changed, and the verbiage changed. And it said that I was soliciting these women for sex. Nowhere on those text messages will you see that any money was going to change places. For God's sakes, one of them came and met my family and became my girlfriend, and she works for the state of Connecticut. She almost lost her job because I was incarcerated.
I understand. All right, so Attorney O'Brien, is there anything you'd like to say before I?
No, thank you, ma'am. I think we've addressed the central issues that ultimately this is a violation of the terms and conditions of his probation, not the terms and conditions of his parole. At no time did he have any problems faithfully abiding by the rules and regulations of his parole. And we would respectfully ask you to take that into consideration here. Thank you.
Thank you.
One final thing, Ms. Meisinger. There says that on whatever day it was that I missed an appointment with Anne Marie Mushhorn, I used to walk from the Eddy Center on Silver Street all the way down to Main Street, which was a nice walk, but I wouldn't take the bus, and I went for probation. I was always in the afternoons. I remember once or twice going there, and they said that Anne Marie Mushhorn wasn't in the office. One time, another officer saw me. Another time, they gave me an appointment card to come back. And now, here we are, a year removed from that, and they're saying that I missed an appointment. I've never missed any of those appointments. I know my stipulations, and I know that I can be revoked and re-incarcerated. You think I would go out there and I did all my programs here.
I hear you. I hear what you're saying.
Yes,
and
thank you.
do you, one more thing is, do you plan on doing the mental health treatment in the community?
I plan on doing that until I'm gone because it helps me. Where I'm at now is it's insane. I'm doing mental health treatment while I'm here, and that's voluntary. I go to see mental health because it helps me.
Right.
You know,
I just want to know if you plan on doing that when you get back out too. You're going to continue with that in the community?
yes, ma'am.
All right. Is there somewhere you go for that you prefer?
Well, I was going to my own private doctor, Dr. Ken Green, out of Community Health Center,
Okay.
CHC. Probation told me I could no longer see my own doctor. They took me out, and they forced me to go
Well,
to.
I'm just saying if there's somewhere you prefer, like when you go, as far as your release plan goes.
Oh,
where
there
you
is,
plan.
but I don't think I'm going to be allowed to do that because of probation.
Okay. Well, I understand that you want to continue your treatment. You already are in it now, and you want to continue in the community, correct?
Right. They're going to put me
Okay.
back at Wheeler Clinic, ma'am. I'm going to go to 40 Hart Street in New Britain, and I'm going to continue to go there and see Alexis Beckford. That was my therapist there.
Okay.
Thank you.
Yeah.
I just wanted to make sure with that, make sure we were on the same page with that, and that was your plan. So that I'm glad to hear that. I'm glad you're involved in treatment right now at the facility as well.
Yes, ma'am.
So I'm just gonna I have some points to make on the record, and then I'm going to move forward with my recommendation because I have listened to all the testimony today, and I have reviewed all the evidence that was provided by the state. As I previously stated, you did receive that violation of probation conviction, which received a 2-year sentence with 14 years probation to follow. The US date on that is 6/12/26. Your pending eligibility date on that sentence is 6/11/25. And you are on special parole until 6/18/26. You were in the community for about a year before you returned on the probation violation, in which you received that new sentence. Your officer recommended a year incarceration. You did receive 3 misconducts. You have no prior violations on parole. This is your first parole violation. As well as per records, I see no criminal, no past community release is to the community. So this is like your first time. So I am taking that all into consideration, as well as the few minutes that you were late on the GPS, and I look at that as well. So based on all this information I have, I am going to recommend that parole be revoked and that you be re-paroled for 6/11/25, which is your eligibility date for parole on your new sentence. I recommend the following parole conditions: halfway house placement, behavior management program for domestic violence, no contact with your victims KS and JR, no contact with minors without PO's permission, mental health treatment and medication compliance, problem sexual behavior treatment in MOA. My findings are going to go to the parole board on April 10th. So the parole board's going to review my recommendation. They can't lessen it. That's the least sanction that I can give, which is that ends up being a year sanction. So they can let my sanction stand, or they can impose a longer sanction than what I've recommended. So they can revoke all special parole or extend that sentence if they do want a longer sentence. They can impose. If they do want something longer than what I've recommended, they bring you back and you'd have a supplemental hearing, and then you would talk to them if they had any concerns. Do you have any questions about that, sir? You understand?
I understand everything perfectly, but something that happened when we went back on January 9th, just going back to January 9th, 14 years probation? Because you said that I have a suspended sentence of 13 years. But you read that last part. Just I don't understand. 14
I'm reading
years.
what the addendum says.
Yeah,
So,
I know. I don't. That doesn't. Why didn't it change, Attorney O'Brien? Remember we talked about that when you came here to visit me.
Well, that's not.
well, you were sentenced to 13 years, execution suspended after 2 years with 14 years probation.
That's probation, and that's a separate proceeding with respect to the court, as opposed to the parole, which has to do with your Rockville case. Mr. Rosario.
So my probation went up.
If you have questions, you can call your attorney. Unfortunately, with the court issued, I can't explain, but, so on April, like I said, April 10th, you're gonna know, what the board's decision is. You can talk to your attorney because he will be notified. We'll let him know, or you're gonna get it a week after in writing from us too. So you'll get what the board's decision is in the mail. Okay?
Okay.
All right, so you're all set. I'm trying to give you another chance to go up. You were doing well with us on parole. So I hope you continue, doing that in the community, okay?
Yes,
I will.
thank you. He will.
Thank
All right,
Thank
so
you.
you're all set for today, then work on getting me the sponsor information if you want me to enter that, just, okay?
We will.
I will,
Thank you.
if I address the letter to you and the attorney, I can just put your I have your name
Yes.
on my documents and send it right to Waterbury?
Yes, you can do that if you'd like. Yep.
Okay.
Okay,
Okay, so you're all set for today, sir.
thank you.
Thank you, Attorney
Thank
O'Brien.
Yes,
Thank
thank you,
you.
ma'am. Bye-bye.
Have a good day.
I'll give you a call,
Bye.
Mr. O'Brien.
Okay.
All right, I'll call
Thank
you.
you.
Okay, bye.
Morning.
Good morning, sir. I'll be right with you. Good morning, sir.
Morning.
We're here today for your revocation hearing,
Yes.
so we're gonna get started, okay?
Yep.
Good morning, I am Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Rivera, Waldemar, number 249194. Today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office in Colorado Robinson Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
I'm Waldemar Rivera, 249194.
You have counsel here today. Who's identify yourself?
Good morning, Public Defender Robert Famiglietti of the Parole
Good morning.
Revocation Unit. Hello, sir.
Hello.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole. We can release you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. The panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all of the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Okay, you have important rights today. You have right to have an attorney present. You have counsel here. You have a right to receive the written notice that charges the violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you for the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge the state your PO is bringing against you and the information underlying each charge. So charge 1 or bail laws, obedience to the law. Your charging officer reported on 11/6/24, you were operating a motor vehicle. You failed the one-leg stand and walk and turn field sobriety test. It was determined you were under the influence of alcohol and submitted a chemical breath test sample, which indicated a positive result of .1906 VAC. Based on your actions, you were charged with operation of motor vehicle under influence of alcohol and or drugs and failure to obey a stop sign. Charge 2 under no consumption of alcoholic beverages. You're charging officer reported on 11/6/24. You're operating a motor vehicle. You failed the one leg stand and walk and turn field sobriety test. It was determined that you were under the influence of alcohol and submitted a chemical breath test sample, which indicated a positive result of .1906 VAC. On 11/8/24, you signed a voluntary admission form indicating that you drank alcohol. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, conditions of special parole. B, decision information summary. C, Bristol Police Report ending in 45073. D, voluntary admission form 11/8/24. E, judicial branch pending case detail. F, remand actual custody order. G, parole violation report. And H is notice of parole violation. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Yes.
And I will put on the record, I've seen addendum from PCS. The addendum reported on 2/26/25. Were convicted of illegal operation of a motor vehicle under the influence of alcohol or drugs, with all their charges dismissed, and received a sentence of 6 months, execution suspended for 2 days with 18 months probation for that. And counsel has filed the following exhibit that is pre-marked for identification purposes. That's Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement, and Exhibit 2, which is a letter from an employer. Do you need to continue this hearing to obtain any additional evidence?
We do not.
Okay, we don't have any witnesses today, so it's now defense's opportunity. If you'd like to speak to any evidence at this time?
As a result of the conviction and the admission, and no comment as the preponderance standard.
All right, so what I'm going to do next is I'm going to announce my findings. So on that charge 1, I do find you violated that condition, obey all laws, obedience to the law, based on your conviction of illegal operation of motor vehicle under the influence of alcohol or drugs, and received a sentence of 6 months, execution suspended after 2 days, 18 months probation, with all our charges dismissed, as well as exhibits that showed that were provided A, C, and D. On charge 2, I do find you violated condition no consumption of alcoholic beverages based on the evidence provided, which is exhibits A, C, and G. And that includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to.
Yes, he was out on parole for some time. He was remanded on November 20th. This is his first violation. He's a first offender, mandatory minimum sentence, no accidents, no injuries, admitted the alcohol. As I stated, this is his first violation. He's 45 years of age. He received supports from his cousin, aunts, and his significant other, Rosemary Lugo. He has earned 30 general studies credits. He was did junk removal at Junk General. He was full-time there. And most recently, beginning in February of 2024, he's working full-time metal sorter at ELG Utica Alloys. I draw your attention, he was also training new hires. I draw your attention to Exhibit 2, which is an excellent letter from his employer. His focus attentive to detail. His vision as a metal sorter was the hardest to learn. He's not only mastered the job, he's now able to train new hires. I will personally vouch for him. He's a valued member of our team. Signed Maureen Brogan. My client, I believe that he should be released at the next possible date. The parole officer is recommending 5 months. He's been in for approximately 4 or 5 months. I'd ask that he be released as soon as possible. He was engaging in individual psychotherapy, Willard Clinic, weekly outpatient services. While incarcerated, he completed a DUI program, New Thoughts program, employed as a detail worker beginning of January. He'd like to be sponsored once again by his cousin, Jose Lopez in Southington. And he can return, as the letter states, to Utica Alloys Incorporated. He's amenable to all treatment recommendations. I think this is pretty straightforward, no violence. And I think that he should be monitored back on parole as soon as possible. Thank you for your time and consideration.
Thank you.
I will.
So I have reviewed all the evidence provided by the state and listened to testimony. I will put on the record, the offender was on parole for about a year before he returned on for the new conviction he received for illegal operation of motor vehicle under the influence of alcohol or drugs. He did complete that sentence at this time, does have 18 months probation to follow. Okay, he does have no misconducts and no prior parole violations on this period of supervision. He is on supervision until November of 2028 for special parole. The officer did recommend 5 months or until the criminal matters are disposed. Based on all this information, I'm going to recommend that parole be revoked and that you be reparoled for April 10th, 2025. It's an approximate, it's 4 months and 21 days, period of confinement as a sanction. I recommend the following parole conditions: no consumption of alcoholic beverages, operation of motor vehicle, no contact with your co-defendant, Ivan Luciano, and no contact with victims, family of the deceased victim, KC. My findings go on the parole board on April 10th. So if the board agrees with me, you would be released that day. If they don't agree with me, that means they want a longer sanction. So you'd have a supplemental hearing and the board would bring you back to talk to you if they decided they would want that. And you would be notified of that. Do you have any questions?
But if they agree to it, will I hear about that as well?
You'll be released that day, so you'll know. If they say yes on April 10th, you're leaving that day.
Okay,
So you'll know. If you're there past April 10th, that means that you're going to get a letter.
Yeah.
And you can talk to your attorney as well.
So you should hopefully be released on April 10th, which is in about 11 days.
all right,
Okay? If you don't get released on that day, call me, okay?
all right.
All right, take care, sir.
You too.
You're
You
all
guys have
set.
a good morning.
You too. Have a good day. Oh, wait.
Did you need me?
No, you're all set.
Oh, all right, all right.
Morning, sir.
Morning.
Mr. Wills,
Yes,
we're here today for your preliminary hearing.
yes,
Okay, so we're going to proceed with that at this time, okay?
yes.
Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Willis Kevin, number 135763. Today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office in Colorado Robinson Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Kevin Wills, 135763.
This is a preliminary hearing, which the purpose is under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I reinstate your parole, which is releasing you placed back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No,
Okay, important rights today. The right to have an attorney present. Do you want to continue without counsel?
no, I'm all right.
So you want to proceed with the hearing today?
Yes,
Okay. You have a right to receive the written notice charges the violation. Did you receive the written notice?
yes,
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
yes,
All right, so now I'll review the charge the state your appeal is bringing against you and the information underlying each charge. So charge 1 or release direction GPS, you're charging officer reported on 3/11/23, you did not return home to your parole approved address and did not have permission to be anywhere else. On 10/12/24, you did not return home to your parole approved address, did not have permission to be anywhere else. In addition, you failed to charge GPS as required, resulting in a 5-hour shutdown. Charge 2 is curfew. Your parole officer stated on 3/11/23, you failed to return home by 9 p.m. curfew and failed to return until the following day on 3/12/23. On 10/12/24, you failed to return home by your 9 p.m. curfew. Charge 3, no bail laws obedience to the law. Your charging officer reported on 3/11/25, you're involved in a domestic incident with your co-worker, ex-girlfriend while at work. Witnesses reported you approached the van where the victim was sitting and you began to yell at her, telling her to get out of the vehicle. When she refused, you reportedly smacked her several times in the head. You then placed both your hands around the victim's neck, strangling her. You threw her to the floor of the van and grabbed her by the arm, dragging her out of the van to the sidewalk, where you continued to repeatedly hit her in the face and neck with your hands. Subsequently, you arrested and charged breach of peace second, assault third, unlawful restraint first. A remanded custody order was lodged. On 3/12/25, you were arraigned at GA 14 and probable cause was established for the next court day of 4/16/25. Charge 4 under drugs. Charging officer reported on 8/14/23, you rendered a urine that was positive for cocaine. 3 errata results confirm your consumption of cocaine. At no time are you to consume illegal substances. On 9/14/23, you voluntarily admitted to the use of cocaine and signed a voluntary admission on 9/15/23. On 9/15/23, you rendered a urine that was positive for cocaine. Redwood Toxicology Lab confirms your consumption of cocaine. At no time are you to consume illegal substances. On 10/13/24, you verbally admitted to the use of crack cocaine. On 10/17/24, you signed a voluntary admission. At no time are you to consume illegal substances. On 2/18/25, you voluntarily admitted to the use of crack cocaine. On 2/19/25, you signed a voluntary admission, rendered a urine. Premier biotech results confirm your consumption of cocaine. At no time are you to consume illegal substances. And charge 5, under no consumption of alcoholic beverages. Your charging officer on 3/11/25, parole staff entered your apartment and you were actively consuming a natural ice alcoholic beverage and verbally admitted to drinking alcohol. At no time are you to consume alcoholic beverages per your conditions of parole. So you're now, the state has also filed the following exhibits that are pre-marked for identification purposes as A, PCS conditions of parole, B is remand the actual custody order, C, parole violation notice, D, parole violation report, E, GPS agreement, F, misconducts and supporting evidence of voluntary admissions at night GPS and lab results. G, Hartford police report, case number ending in 5432, and H is photographic evidence. Did you receive notice of parole violation report, and the other documents I marked, and did you review those?
I got everything.
Okay. Do you need to continue this hearing to another date to obtain additional evidence?
No, I just want to say, that police
Well,
report.
I'm gonna give you a chance to talk. Don't talk yet. We don't have any witnesses yet. So now is going to be your opportunity to respond to parole violation charges against you. However, remember that you may remain silent if you so choose. So I'm just going to swear you in under oath so you can speak first. So can you just please raise your right hand? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, nothing but the truth, so help you God on penalty of perjury?
Yes, I do.
All right, go ahead.
All right, the cases of the GPS, all of the relapses, I admit to everything of that. This domestic thing, I would rather take this to trial because I know all of that is a lie. I did make her fall. It was no slaps. It was no drag out of the truck. It was mad people there. I don't understand. There was so many people there and I beat her up like that. Why nobody helped her? You know what I'm saying? I wouldn't want to take it, but you know what? I am so tired of this parole that I would sit up there and cop out to anything they want. But I just want my parole thrown out so I can go down south. I am so tired of this parole stuff, man. You know, but you know, I admit to everything since I've been on here and stuff, but I'm not going to admit to that. I'm not going to admit to it at all. She didn't even press charges. They don't even believe her. But the thing is that, you know, my case that I'm on with my parole and stuff, you know, I have bad judgment of relationships, you know, getting the people I put in my relationships. But I'm just tired, man. But I'm not going to cop out to that domestic thing. I'm not going to do that at all. But I'm just so tired of this parole stuff. Man. I just want to leave, man, get out of Connecticut, man. Just get with my family, man, and just, you know, start over and stuff. But I admit to all this stuff ever since I've been on this devourer, you know, and you know, I try to be honest through the whole time and stuff. You know, everything that happened, I went to and told her, you know, but I'm not going to cop out to this. I'm not copping out to that domestic. I did not beat that girl. I was in love with that girl. I did everything for her and everything. But that's up to the court stuff. But I'm just saying like that.
Yeah.
You know, but everything else, I admit that. I admit it. Yes, I do. That's all.
Okay. Well, I appreciate your statements.
Yes. That's so tired. I have a drug problem, you know. That's the only thing I have to do. I have to get somewhere and get some help somewhere, man. I don't know. But other than that, I don't. Just want this over with.
All right, so what then I'm gonna do next is I'm just gonna announce, my findings, unless you, if there's anything else you want to say this time.
No, good.
Okay. Well, like I said, I do appreciate your statements. So I'm going to announce my findings. So on that charge, one, I make a finding of probable cause on GPS based on the evidence and testimony presented in support of the violation, exhibits A, E, and F. On charge two, curfew, I make a finding of probable cause based on evidence and testimony presented, which is exhibits A, E, and F. On charge three, obey all laws, obedience to the law, I make a finding of probable cause based on evidence presented in support of the violation, A and G. On charge four, I make a finding of probable cause, drugs based on evidence and testimony presented in support of the violation, which is exhibits A and F. And on charge five, no alcohol consumption, I make a finding based on testimony that was provided. So I do find the act serious enough to warrant revocation. Attorney should be detained, wait for your rev hearing. So you are, I know you were on special parole until April 27. So what's going to happen is we'll bring you back after those charges are disposed. And then we'll determine if there's a violation moving forward after those charges are disposed of. Do you know when your next court date is?
The 16th of April.
Okay, so I'm gonna be notified whenever this, I know that you might choose to fight this, or, so that's, whatever happens with that, whenever that's done, then I'll see you again.
Okay.
Okay?
Yeah.
All right, so you're all set, sir. I wish you best of luck.
All right. Thank you.
Thank you. Good morning.
How are you? Good morning.
Good.
Mr. Maldonado,
Yes, is Ilchert there?
do you want him at the same time or?
No, I
Oh,
just,
okay. I didn't
I'm
think-
just gonna continue his case. I just wanted him to, come in so I can talk to him and continue his case.
Oh, okay. He's not in right now. I'll let him go first, but I have to grab him from the unit.
Oh, he's still in the unit?
Yeah.
All right, so I got something from his attorney, so he doesn't need to be present. So I'm just gonna continue on the record without him, so he doesn't need to come down.
Okay, sounds good.
Thank you.
Thank you.
Thank you.
All right, Mr. Maldonado, I'm just gonna, do that continuance I just stated on the record. So this does not pertain to you, okay?
Okay.
Just put a new battery in here.
You don't put that in?
You see that? Okay.
Okay.
Thank you.
All right. Okay, regarding inmate Christopher Ilchert, number 424-677, there's going to be continuance granted at the request of the offender's attorney. He will be heard for his revocation hearing on April 8th, 2025. All right, Mr. Maldonado, we're here for your revocation hearing, so we're going to get started with that, okay?
Yes.
Good morning, I'm P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Maldonado Jacob, number 399372. Today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office in Bridgeport Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Jacob Maldonado, 399372.
You have counsel here today. Please identify yourself.
Good morning, Hannah Dean for the record on behalf of Mr. Maldonado.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better reader evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is release you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. Council will then have an opportunity to present our relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, council will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today, right to have an attorney present. You have counsel here. You have right to receive the written notice, charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence supporting your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, I do.
All right, so now review the charge, state your appeal is bringing against you, and the information underlying each charge. Charge 1 under absconder. You're charging officer report on 7/2/23. You signed out of the Bishop halfway house. Your only parole approved PCS residence at 12 p.m. to attend religious services at Church Street, Waterbury. You were expected to return at 3 p.m. and failed to do so. Staff attempted to contact you on your cell phone, at which time you answered the phone, remained quiet, and then disconnected the call. Staff attempted to call your cell phone again and were unsuccessful as it went straight to voicemail. Local hospitals and jails were contacted, were not found admitted to either. You have failed to contact Bishop House, Halfway House, or your PO, leaving your whereabouts unknown in the community. Charge 2 and obey all laws of use of the law. You're charging officer report 8/13/24. You're arrested and charged with fleeing or attempting to elude an officer, flight to avoid apprehension, driving while under the influence, driving without insurance, careless driving, driving at safe speeds, driving without a license, and required rear lighting. These charges occurred while driving a vehicle out of state. Charge 3 under travel. You're charging officer report at 8/13/24. You're apprehended in the state of Pennsylvania on 2/10/25. You signed a waiver of extradition in the Court of Common Pleas of Schuylkill County, PA. You did not have permission to leave the state. It's a clear violation of your conditions. In the state, follow following exhibits that are pre-marked for identification purposes as Exhibit A, PCS conditions, B, parole violation notice and parole violation report. Exhibit C, Bishop House incident report. D, Bishop House discharge report. E, remand of custody order. And F is parolee rights. G is Pottsville Bureau of Police report. And H is signed waiver extradition. Did you receive notice of parole violation report, and those other documents I marked? Did you review those?
Yes, I did.
And I will put on the record, I did receive an addendum from PCS, and the addendum reported at 8/4/23. The BOPP did issue an absconder warrant for the offender. And it is noted that you were found guilty in Pennsylvania of fleeing, and which you received a 6 to 23 months sentence for incarceration, and for the DUI, which you also received the conviction to 3 to 6 months sentence for that. And counsel filed the following exhibit that is pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, I don't.
Okay, we have no witnesses today. Is now defense's opportunity if you'd like to speak to any evidence submitted?
Yes, thank you. I don't have any comments as to the preponderance standard, but I just had some global remarks I wanted to make about the charges. This was an unfortunate situation. I spoke with my client at length about this. He reports the Wildemar halfway house. He learned that his parents were both experiencing some significant medical issues, specifically his mom, who resides out of state in PA, was very sick. His dad was also struggling. And unfortunately, my client did try and go through the proper process, but was told that he was unable to leave because his family was out of state. I will note, however, that the addendum is accurate. My client did complete that sentence in PA. No more time to serve is required there, so that is finished. And in that case, the allegations were that once apprehended, he was compliant with the police. I would also note that he was compliant being served with this parole remand and willingly waived extradition to come back here. So I would just like to make those remarks, and at the appropriate time, I would like to talk about his background and history. Thank you.
Thank you. Right, so what I'm going to do next is I'm going to announce my findings. So regarding charge 1, I do find you violated the condition and release restriction of absconder based on a warrant being issued by the BOPP and evidence that was provided in support of the charge, which exhibits A, B, C, and D. On charge 2, I find you violate condition, obey all laws, obey to the law based on your conviction of fleeing and received a sentence of 6 to 23 months, and DUI received a sentence of 3 to 6 months with all our charges not processed. Also based on exhibits A, B, and G. On charge 3, I do find you violate condition travel based on the evidence provided in support of the charge, which is exhibits A, G, and H. So that includes the fact-finding portion of this hearing. Before we make a recommendation, the council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you very much. My client, Mr. Maldonado, is 34 years old, born in the state of New Jersey. He was raised there and then also in Meriden, Connecticut. His primary source of support is his family. His mom resides in Pennsylvania. His father, 3 sisters, and 4 brothers reside between New Jersey, Massachusetts, and PA. My client's mother is in very poor health. He has 3 sons as well, ages 16, 15, and 13, all of whom reside in Massachusetts. Upon release to special parole in January 23, my client first utilized the sponsor, who was his sister in New Britain. He then was at the Chrysalis Center Scattered Site Program in Meriden until June 2023. And then from June to July was in Bishop House. My client was full-time previously a Precision Landscaping in Meriden. He's worked for that company on and off for a number of years. He also was full-time for Official Asphalt out of New York and was in that position for approximately a year and a half. He reports that he recently underwent surgery in January 2025 as a result of an accident. He is supposed to be participating in physical therapy, though unfortunately they don't have him doing that currently at the facility. My client has not received any disciplinary tickets whatsoever since his remand to custody. Upon reinstatement of special parole, he would like to return to PA and be sponsored by his mom, Ariana, at an address in Port Carbon, PA. I did explain that that process takes approximately 3 months of doing well in the community before getting the paperwork started. So, Mr. Maldonado, is there a specific jurisdiction in Connecticut where you would like to have a halfway house? Because it will take a little bit of time for them to process your request. Where's the best area for you for a halfway house?
It doesn't matter wherever you put me.
Well, Hartford, Waterbury, New Haven, Bridgeport.
It doesn't. It really don't
Well,
matter.
you tell me. You tell me which one you want.
Hartford.
Hartford.
Okay. He also is hoping once he's reinstated to go back to the asphalt industry. He one day wants to start his own business in that industry as well. He's very eager to be present for his children. He wants to rebuild those relationships, move further forward as a family together. He's open to any sort of treatment recommended, including completing Explore. He also is looking forward, as I said before, to beginning physical therapy to address those health concerns. I would argue that the sanction for my client should not exceed 6 months. He has effectively already served 7.5 months as he's been incarcerated since August 13, 2024 for the conduct that's currently the subject of this remand. As I noted, once he was apprehended, he was completely compliant. He willingly waived extradition to come back to Connecticut and handle this situation. I would ask that you consider that amount of time that he was incarcerated in PA and making a recommendation. As I said, he has been incarcerated there since August. Even if you were not inclined to honor the amount of time he was in PA, I would ask that at the very least he receive credit from the time in which he waived extradition until he was brought back here to Connecticut. So that was on 2/10/25.
Thank you.
Thank you.
So I'll be right with you with the recommendation. So I've listened to testimony today and I have reviewed all the evidence provided by the state. I do want to put on the record, you were in the community for about 5 months. Well, you were in the community for 5 months and 10 days before you absconded from supervision. You absconded for approximately a year and 1.5 months and went to another state without permission. This is the second time that you have absconded and returned with new criminal charges. A 6-month sanction was given last time, as I can see from our records. So again, you've returned with new charges after serving time in Pennsylvania. Your officer recommended a 9-month sanction minimum. Based on the information I have, I am going to recommend that parole be revoked and that you be reparoled for October 26, 2025. This is about an approximate 8-month period confinement as a sanction since your return to Connecticut custody. I will note the offender was in custody in PA on 8/13/24, which is approximately 1 year and 3.5 months. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, operation motor vehicle, behavior management program for domestic violence, no contact with your victim JF and CM. My findings are going to the parole board on April 10th. The board's going to review this. The board has the options to let you out earlier, so they can let you out as soon as 4/10. That's the earliest date. They can agree with my sanction of 10/26, or they can revoke all special parole or do a later time if they would like. You are on special parole to October of 26. I understand you do want to go back to Pennsylvania, but you have to wait for the process. So you could do it the right way and get off special parole, or else we're going to stay in this process of you violating coming back if you don't do it the right way. So you do understand that. I understand you probably want to be in Pennsylvania to be with your family. So I hope that you can follow the process and so we can get you out there after you show you're in compliance. Okay? Do you have a question?
So, Mr. Maldonado, if you would like to call me on April 10th or the following day, the 11th, I can update you on what the board decides, okay?
Okay.
All right, thank you so much. I'll talk to you
Thank you.
then.
All right,
You're all
thank you.
set. Good luck, sir.
Thank you.
Take care.
Okay.
Good morning.
Morning.
Is it Mr. Crawford?
Yes, good morning.
Good morning. Good morning, P.O. Barnick.
Good morning.
So I'll just go on there. Good morning, I'm P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing, starting Crawford, Ramell, 435-394, and today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office, MacDougall Correctional Institution. This is a public hearing and public access hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Ramell Crawford, 435-394.
We have a PO present. Please identify yourself.
P.O. Bartnick, Waterbury District.
And we have counsel here today.
Yes, good morning. Hannah Dean on behalf of Mr. Crawford. Good morning.
Good morning.
Yes, so at this time, I did get a chance to speak with my client this morning, and at this time, we would like to waive the preliminary hearing for this matter and go forward once his case is resolved in criminal court with the revocation hearing.
Okay, so I'm going to accept that request, and so we will waive the preliminary hearings today. So Mr. Crawford, you will come back once your charges have been disposed. Then we'll have your revocation hearing and determine if there's a violation or not. Okay?
Okay.
Okay, so we are all set for today then.
All right, thank you very much. I'll be in touch with you and your partner, Mr. Crawford.
All right, thank you.
Have a good day.
You too.
Oh, done already?
Yeah, where is the?
Oh, okay.
Morning.
Good morning.
Morning, Mr. Green.
Yes.
Perfect. All right, we're here today for your preliminary hearing.
Okay.
All right, so we're going to get started. Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Green Eric, number 331660. Today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. This is a public hearing and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Yes, Eric Tyron Green, inmate number 331660.
This is a preliminary hearing, which the purpose under Connecticut law is to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole. We can release you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge that the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
Thus far, no.
Okay. You have important rights today. The right to have an attorney present. Do you want to proceed without an attorney?
Yes.
You have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, I did receive the written notice. I have.
Okay. You have a right to review the evidence against you. You have a right to submit evidence in support of your case at this hearing. You have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, I am.
Okay, so now review the charge the state your PO is bringing against you and the information underlying each charge. So on charge 1, under release restriction program participation, your charging officer reported on 3/6/25. You failed to report to CRT Behavioral Health Services for your CBT group. CRT Behavioral Science staff advised PO you failed to notify the program that you would not be attending group. On charge 2, under obey all laws, obedience to the law, your charging officer reported on 3/13/25 you engaged in a violent encounter with your parole officer when parole attempted to remand you into custody by attempting to flee the scene and causing parole to have a physically intervene and arrest you. And charge 3, which is search, your charging officer reported 3/13/25. Your parole officer instructed you to comply with a path search at the entrance of your apartment building. You failed to comply with this officer and other officers' direct orders to keep your hands on the wall during the path search. You also failed to allow the officer who was conducting the path search to search your pocket by blocking the officer from searching your right front pocket. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, Connecticut Conditions of Parole. B, Connecticut Board of Parole Remand to Extra Custody Order. C, Notice of Parole Violation, Notice of Parole Rights. D, Parole Violation Report. And E is CRT BHS Attendance Email. Did you receive Notice of Parole Violation Report, and those other documents I marked? And did you review those?
Yes, I would like to dispute one of those, please, if I could.
I'm going to give you an opportunity in 1 minute, okay?
Okay.
So do you need to continue this hearing to obtain any additional evidence?
No.
Okay. So now is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you so choose. So I'm going to swear you in under oath so you can speak today. So can you please raise your right hand? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
All right, so go ahead, sir.
The first statute I would like to dispute with the.
Do you mean charge or do you mean
not attending the group? That
Okay.
Thursday I was with Delisha what is his name? Phillips. And throughout the whole day, it was pretty much a whole day ordeal just getting me transitioned from the Cheney House to Ashley Street. And Delisha Phillips knew about that, and she pretty much excused me for that day to be excused because I still had to go to work after we did what we did to get to the apartment that day. So that's the only dispute I had.
Okay. So do you want to say anything in regards to the other charges or no?
With the other charges, you know, I just did 8 years in prison. As you know, it's on file. I suffer from PTSD, which is on file. I also have a medical marijuana card that is also on file, and I'm not no professional at this, but I believe that's what kind of threw me off that day, because there was no reason for me to react the way I did when the officers approached me and asked me for a regular pat down. There was absolutely no reason for me to act upon the way I did that day.
Okay. Anything else you want to say before I announce my findings?
Yes, I knew I was doing the right thing. I was working every day. Just a week before the incident, I had took my kids out to Dave and Buster's. We had a great time. I'm just eager just to get back into community and just to work on myself, work on that PTSD, and to continue being a good father towards my children, and just, you know, continue on with my life, I would say.
Okay. All right, so I'll be right with you with my findings, okay?
Okay. All right, so I'm going to announce my findings. So on charge 1, condition least restriction program participation and make a no finding of probable cause based on the charge not meeting the elements. You missed only one group. On charge 2, in testimony also, you did state that was excused. On charge 2, I do make a finding of probable cause on obedience to the law based on the evidence presented in support of the violation, exhibits A and D. And I make a finding of probable cause on charge 3, search based on evidence and testimony presented in support of the violation, exhibits A and D. I determined the act is serious enough to warrant revocation. I determined it should be detained while you wait for your rev hearing. So what I'm going to do, you don't have pending charges, so you're a technical violation. So I'm going to schedule you to come back for a rev hearing to determine if there's a violation or not. We have 60 business days from your return to custody to schedule that. So I will schedule that very shortly. So I'll see you again, and then we'll determine if there's a violation or not. Okay. Can I ask you one question, please, Selena, before we end the conversation?
You can ask me a question. Yeah.
Being that if you guys do find me in violation, how long, can you give me a ballpark number of like how long I will have to stay?
No, it depends on if there's a violation or not. We have to get to that point.
I can't give you a guess right now. We'd have to determine what happens at the rep hearing. That's what that's for.
All right, and like I said, like I apologize, and I'm tired of I'm really tired of apologizing because it should have been easy peasy that day. And like I said, I really do think my PTSD kicked in, and I just had a freak out situation. I really freaked out for no absolute reason at all. No reason.
Okay,
No
well,
reason.
we can talk about that then, and I'm glad you're taking time to actually think about what happened and maybe different ways you could handle things.
Yeah, I'm taking full responsibility for what I did because I know it could have easily went the other way, and we won't be here talking right now. But
exactly.
Due to my circumstances, I'm still working on myself. I was attending Willer Clinic probably once every other week, working on my therapy.
Well, we're gonna talk about all that at your rep hearing. So,
Okay.
Because you're done for today, so we'll talk about all that at the next hearing, okay? So I'll send you a notice. We're gonna let you know when to come back, okay?
Okay.
I'll see you soon.
All right. Thank you.
You're welcome. Have a good day, sir.
You too. The hit button. Right here.
Here we go. Sorry, hi, good morning.
That's okay. We had some issues this morning too, so.
Okay. And I have Hutto here for you.
Thank you very much.
You're welcome. Come on in.
Yo, Rios, are you there? Good morning, Mr. Hutto.
Good morning. Good morning. How are you?
Good, how are you?
I'm great. Great.
Okay, I'm just waiting for your PO to join and then we'll get started.
No problem.
Yo, Rios, are you there? If you are, you just have to.
Yes,
unmute
I'm
yourself.
here.
Oh,
Hi,
perfect.
how are
Just
you?
just making sure. We've had problems with audio today a little bit, so. All right, so we are gonna get started.
Yeah.
Actually, yes, we're gonna start. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing. Starting Hutto Jeffrey, number 361456. Today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record, sir?
Jeff Hutto, 361456.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
Parole Officer Reyes, New Haven
Thank you.
District Office.
Thank you. This is a preliminary hearing, which is the purpose of Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine the act's sufficiency or to warrant revocation of your parole, and to determine you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is release you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note you've been referred by the Department of Corrections for diversion for substance abuse programming and treatment. If by the end of the hearing I determine you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge and state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue a probable cause and the severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin, sir?
No.
Okay. Your important rights today, the right to have an attorney present. Would you like to go forward without an attorney?
Yes, ma'am.
All right, you have a right to receive the written notice of charge of the violation. Did you receive the written notice?
Yes, I did.
You have a right to review the evidence against you. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
All right, so now review the charge that the state, your parole officer is bringing against you and the information underlying each charge. PO, please read the charges.
Charge 1, program participation. On January 14th, you were referred to MCCA for outpatient treatment. MCCA recommended that you attend treatment 3 times a week. You did not attend treatment 3 times a week as recommended by your treatment provider. This violates your special parole condition that states I will be assigned to one of several levels of community supervision and agree to participate in programs as determined by parole officer. On 12/3/2024, you allowed an unauthorized female and her dog to reside in Reach's DOC scatter site reentry assisted community housing REACH program overnight. You signed REACH client participation contract that states I understand that there are to be no visitor overnight guests in the apartment. This violates your special parole condition that states I will be assigned to one of several levels of community supervision and agree to participate in programs as determined by my parole officer. On March 14th, 2025, you were unsuccessfully discharged from the REACH program due to having 2 unauthorized visitors, alcohol and drug paraphernalia in the residence. This violates your special parole condition that states I will be assigned to one of several levels of community supervision and agree to participate in programs as determined by my parole officer. Charge 2, drugs. On 1/7/2025, during your case management session at REACH, you rendered a urinalysis that was positive for cocaine. This violates your special parole condition that states I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. On 1/13/2025, during your case management session at REACH, you rendered a urinalysis that was positive for cocaine. This violates your special parole condition that states I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. On 1/28/2025, during your case management session at REACH, you rendered a urinalysis that was positive for cocaine. This violates your special parole condition that states I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. On March 6, 2025, you rendered a toxicology screening while at MCCA outpatient treatment. You tested positive for cocaine. This violates your special parole condition that states I will not use or have in my possession or control any illegal drug, narcotic, or drug paraphernalia. Charge 3, no consumption of alcohol. On 3/14/2025, you were in possession of 3 bottles of alcohol, 3 bottles of alcoholic beverages. The bottles were removed from your pockets by parole staff. This violates your additional condition that state throughout your period on parole, you are prohibited from the consumption of alcoholic beverages.
Thank you. The state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, statement of understanding, agreement, conditions of parole, B, remand to actual custody order, C, notice of parole violation, D, notice of parole rights, E, parole violation report, F, decision information summary, G, reach client participation contract, H, photos of incident, I, offender misconduct, J, emails from MCCA, K, reach unsuccessful discharge report, L, reach incident report, M, second notice of parole violation, N, New Haven CC Class A disciplinary report, and O is third notice of parole violation. Did you receive notice of parole violation report, and those other documents I marked, and did you review them, sir?
Yes, ma'am, I did.
All right. Do you need to continue this hearing to obtain any additional evidence?
I do not know.
Okay. We have no witnesses today. So at this time, the state will have an opportunity to make a short statement, call witnesses, or testify with respect to probable cause and the severity of the allegations. I'm going to swear in you as well, Mr. Hutto, in case you would like to speak today. So can you both please raise your right hand? You solemnly swear, solemnly affirm as the case may be, the evidence shall give concerning this case should be the truth, the whole truth, and nothing but the truth, to help you God upon penalty of perjury?
Yes, I do.
All right, so at this time, it's the state's opportunity. If you'd like to make any statements.
I would just like to say that Mr. Hutto has been given the a couple of opportunities to actually engage in his outpatient treatment. The reason for me placing him in top at the time was because of, I received the call from REACH, and they were in the house where Mr. Hutto had unauthorized visitors, and he was in process of, he was relapsing. At that point, outpatient was no longer an option at the time for his own safety and for the safety of the program itself. I believe that Mr. Hutto will benefit from top placement to kind of get himself back on track so that he can go back out and get another job, as we discussed, and that he can maintain his sobriety.
Thank you. Okay. So now is the opportunity to respond to parole violation charges against you. However, remember that you may remain silent if you so choose. Would you like to respond to the charges, sir?
I agree with her. I was in a bad headspace. I do believe that I'll benefit from the proper run as well. The little timeout that I have right now, it's healthy for me, I believe. And I do think that she did the right thing. That's all. Something.
Thank you. I appreciate your statements. All right, so what I'm going to do next is I'm going to announce my findings. So on that charge,
On charge one, I do make a finding of probable cause. Police direction program participation on part one. So this is labeled parts 1 through 3. 11425 being part one, based on the evidence that was presented for the violation of parole, which is exhibits A, E, and J. A no findings made on parts 2 and 3 as it fails to meet the elements of the charge. Its reach is not considered a program. On charge 2, I make a finding of probable cause, obey all laws, drugs, based on the evidence presented in support of the violation of parole, which is exhibits A and J and E. On charge 3, I make a no finding on no consumption of alcoholic beverages. There's no finding of probable cause based on the charge not meeting the elements. The offender did not consume alcohol. But I do find the act was serious enough to warrant revocation. Attorney should be detained. So DOC recommended you from diversion from revocation process for substance programming and treatment. That means if you want to participate, apply, and I find that you meet the criteria, I can continue your case while you're provided an opportunity to participate in the programming and treatment in the correctional facility. If you successfully complete the programming and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programming and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked, what if any sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and do you want to apply for it, sir?
Yes, ma'am, I understand it, and I do want to apply.
All right, so I will now announce my findings with respect to your eligibility. If I determine you are eligible, I can accept your application and divert you from revocation. So I have reviewed all the relevant information. My finding is as follows. I find you have no pending misdemeanor or felony charges. I find your discharge date is more than 60 business days from the date of your remand to custody. I find there's evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with terms and conditions of parole. And I find there's some evidence that you have received or provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. So I have determined you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask you to indicate whether you understand the following by saying yes or no. I understand I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes, I understand.
I understand that dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of the top program.
Yes, I understand.
I understand that ultimately the DOC will determine whether I have successfully completed the top program.
Yes, I understand.
I understand that my participation in this process is completely voluntary.
Yes.
So your application for diversion is granted. You're placed in the programming and treatment by DOC and diverted from revocation for no more than 60 business days. So upon completion of the program, I will be notified and I will reinstate your parole. Do you have any questions, sir?
I do not.
Okay, so I wish you the best of luck with the program and I hope it helps you out before you come back out.
All right, thank you very much. I appreciate your time.
All right, have a good day, sir.
You
Thank
as
you,
well.
P.O. Rios.
Thank you.
Thank you, Peter. Thank you, Ms. Rios.
Have a good day, sir.
All right, you as well. Thank you.
Have a good day.
All right, you're welcome.
Thank you very much.
All right,
Have a good
thank
day.
you. You too.
Pasa la información.
That over there, the connection was,
P.O. Hutto.
Yes, good morning.
Good morning. So we're just having a problem connecting to Brooklyn, so we're trying to troubleshoot it right now. So hopefully we'll connect in like a couple minutes.
No problem. Thank you.
Thanks.
Brooklyn, can you hear me?
We can hear you.
Okay, I don't see you on your tablet. If you look at the camera icon, is there a slash through it?
There is not.
So we're not getting any video.
I'm okay to go forward without video as long as either side can hear each other.
Okay, if you're okay with that.
Yes. Is Mr. Padilla there?
He is, yep.
Mr.
Yeah,
Okay, do you want to move forward, Mr. Padilla, with the hearing?
yes.
Okay. All right, so we'll just continue with the audio then.
They probably won't show up on screen, but you'll be able to hear them. So.
All right, thank you.
Yep.
All right, Mr. Padilla, I have your attorney here. P.O. Hutto is online as well as we have an interpreter for you.
Okay, thank you.
Do you want the interpreter to interpret everything or just what you do not understand?
Everything, please.
Everything, okay. All right, so we're gonna get started. Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing starting Padilla Carlos, number 427911. Today is March 31st, 2025. This hearing is being conducted via video at the BOPP Central Office in Brooklyn Correctional Institution. This is a public hearing and public access to this hearing is available via video live stream. You please state your full name and DOC inmate number for the record.
Buenos días, el oficial Meisinger, examinadora de audiencias para la Junta de Indultos y Libertad Condicional. Esta es una audiencia de revocación referente a Carlos Padilla, número 427-911. Hoy es lunes 31 de marzo y esta audiencia se está llevando a cabo a través de video en la Junta de Indultos y Libertad Condicional, localidad central y Brooklyn CI. Esta es una audiencia pública. Acceso público a esta audiencia está disponible vía transmisión en vivo. Si puede decir su nombre y número de confinado para el registro.
Mi nombre es Carlos Padilla. El número de preso es 427-911.
And we have a parole officer present. Can you please identify yourself for the record?
Good morning, Nicholas Hudabenko, Parole Officer, Hartford Special Management Unit.
También tenemos al oficial Judovenco de la unidad de manejo especial.
We also have counsel present. Please identify yourself for the record.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit.
También tenemos al abogado Famiglietti de la unidad de revocación de libertad condicional.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation given to a panel for a final decision. If the panel would suppose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement.
Esta es una audiencia de revocación para determinar si ha violado las condiciones de su liberación. Revisaré y haré hallazgos de hecho en cada uno de los cargos en su contra. El Estado, no usted, tiene la responsabilidad de probar las acusaciones mediante una preponderancia de evidencia, es decir, la mejor evidencia o más pesada debe establecer que, más probable que no, la alegación es cierta. Si no encuentro que haya una preponderancia de evidencia que respalde una violación de una o más de las condiciones de su libertad condicional, restableceré su libertad condicional, lo que significa liberarlo y ponerlo nuevamente bajo supervisión. Si encuentro que ha violado una o más de las condiciones de su libertad condicional, consideraré si su libertad condicional debe ser revocada o no. Si recomiendo la revocación, haré una recomendación en
Presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
Voy a ir sobre el procedimiento de esta audiencia. Primero voy a leer sus derechos, luego revisaré los cargos de violación de libertad condicional que el Estado, su oficial de supervisión, ha presentado en su contra. Luego revisaré e identificaré la evidencia presentada para el registro. El Estado tendrá la oportunidad de presentar testimonios relevantes. Luego de considerar la evidencia, luego de que el Estado culmine, usted tendrá la misma oportunidad. Luego de considerar la evidencia presentada, anunciaré mis hallazgos. Y si encuentro que usted ha violado una o más de las condiciones de su libertad condicional, el Estado también tendrá la oportunidad de hablar acerca de su historial. ¿Tiene alguna pregunta antes de comenzar?
No.
The important rights at this hearing, which I will now review with you, the rights to have an attorney present, and you have counsel here. You will receive the written notice of charges of the violation. Did you receive the written notice?
Usted tiene derechos importantes en esta audiencia, los cuales revisaré con usted. Usted tiene el derecho a ser representado por un abogado, el cual está siendo representado en el día de hoy. También tiene derecho a recibir notificación por escrito de los cargos de violación. ¿Recibió usted notificación por escrito?
Sí.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence supporting your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Usted tiene el derecho de revisar la evidencia en su contra antes de esta audiencia. Tiene el derecho a presentar pruebas en apoyo a su caso. Usted tiene el derecho de llamar e interrogar a testigos voluntarios y de interrogar a testigos adversos. ¿Se entiende estos derechos y está disponible a seguir hacia adelante?
Sí.
We will now review the charge the state your parole officer is bringing against you. Any information underlying each charge. I will note charge 2 and charge 3, no findings were made at the time of the preliminary hearing, so those charges will not be taken into consideration. So P.O. Hudabenko, if you please read the remaining charges.
Sure. Charge 1 under GPS. On 4/5/2024 at 1:22 a.m., You allowed your GPS unit battery to shut down, and it remained shut down until 4:52 a.m., resulting in 3 hours and 30 minutes that your whereabouts were unknown and could not be verified by your parole officer. Your actions violate your signed GPS monitoring agreement, and you signed a misconduct for your behavior.
Ahora estaremos revisando los cargos en su contra. El cargo número 2 y número 3 no se encontró causa en la audiencia preliminar, por lo tanto no van a ser leídos en el día de hoy. En el cargo número 1, bajo GPS, el 5 de abril del 2024 a las 1:22 de la mañana, usted permitió que la batería de su unidad de GPS se apagara y permaneció apagado hasta las 4:52 de la mañana, resultando en 3 horas y 30 minutos en los cuales su paradero fue desconocido y no pudo ser verificado por su oficial de libertad condicional. Sus acciones violan su acuerdo firmado de monitoreo de GPS y usted firmó un reporte de mala conducta por este comportamiento.
Under charge 4, travel, on 10/6/2024, you left the state of Connecticut without your parole officer's permission and traveled to Six Flags Amusement Park in Massachusetts. You provided a verbal statement, which was video recorded and transcribed in a signed written statement, that you visited Six Flags in Massachusetts in direct contact with your girlfriend's children, ages 9, 12, and 13 years old. Your actions violate your signed parole agreement and your parole officer's directions.
En el cargo número 4, viaje, el 6 de octubre del 2024, usted salió del estado de Connecticut sin el permiso de su oficial de libertad condicional y viajó al parque de diversiones de Six Flags en Massachusetts. Usted proporcionó una declaración verbal, la cual fue grabada a través de video y transcrita en una declaración escrita, firmada, que usted visitó Six Flags en Massachusetts en contacto directo con los hijos de su novia de 9, 12 y 13 años de edad. Sus acciones están en violación de su acuerdo firmado de libertad condicional y las instrucciones de su oficial de libertad condicional.
Charge 5, no consumption of alcoholic beverages. On a date between December 2024 and January 2025, you admitted to going to a bar in Hartford and consuming alcohol. You provided a verbal statement which was video recorded and transcribed in a signed written statement that you had consumed approximately 3 beers. Your actions violate your signed parole agreement, specifically your no alcoholic beverage consumption stipulation.
En el cargo número 5, no consumo de bebidas alcohólicas. En una fecha entre diciembre del 2024 y enero del 2025, usted admitió ir a un bar en Hartford y consumir alcohol. Usted proporcionó una declaración verbal, la cual fue grabada a través de video y transcrita en una declaración escrita firmada que usted consumió aproximadamente 3 cervezas. Sus acciones están en violación de su acuerdo de libertad condicional firmado, específicamente la estipulación de no consumir bebidas alcohólicas.
Under charge 6, mental health evaluation and treatment deemed necessary. On 6/26/2023, you missed your scheduled mental health evaluation at CRT, which you had been informed by both halfway house staff and your parole officer of, and were directed to attend. You failed to attend this stipulated evaluation. You signed a misconduct for your behavior.
En el cargo número 6, evaluación y tratamiento de salud mental de ser necesario. El 26 de junio del 2023, usted no se presentó a su evaluación de salud mental programada en CRT, la cual se había informado tanto por el personal de Halfway House como por su oficial de libertad condicional. Usted falló a asistir a esta evaluación estipulada y usted firmó un reporte de mala conducta por este comportamiento.
Charge 7, no contact with minors. On 4/20/2024 and continuing through 1/1/2025, you were in direct contact with minors. You provided a verbal statement which was video recorded and transcribed in a signed written statement that you had been in the presence of your girlfriend's children, ages 9, 12, and 13 years old. A search of your cell phone also yielded multiple images of you with minor children. Your contact with minors violates your signed parole agreement, CTPSB treatment agreement, and your parole officer's directions.
En el cargo número 7, no contacto con menores, el 20 de abril del 2024 y continuando hasta el 1 de enero del 2025, usted tuvo en contacto directo con menores. Usted proporcionó una declaración verbal, la cual fue grabada a través de video y transcrito en una declaración firmada en la que usted menciona haber estado en presencia con los hijos de su novia de 9, 12 y 13 años de edad. Una búsqueda en su teléfono celular rindió múltiples imágenes de usted con niños menores. Su contacto con menores pone en violación su acuerdo de libertad condicional firmado, acuerdo de CTPSB y las instrucciones de su oficial de libertad condicional.
Charge 8, problem sexual behavior treatment.
Actually, you do not have to read this.
Okay.
The date
Yeah,
of
mirrors it.
4/20/24 and 10/6/24 mirror the previous charges that we just read on the
Sure.
records.
I would concur.
So we're all set with that. I also want to put on the record that the evidence received, we also stated at the time of the preliminary hearing received by the state is all present. There's no additional information from the state. So I'm not going to restate all of the evidence. Mr. Padilla, did you receive notice of parole violation report, and the other documents at the time that we reviewed at the time of the prelim? And did you review the information?
Quería mencionar que la evidencia provista en la audiencia preliminar es la misma que tenemos el día de hoy, por lo tanto no vamos a volver a mencionar la evidencia previamente mencionada. Mr. Padilla, ¿usted recibió todos los documentos que mencionamos para el registro, el aviso de violación a libertad condicional, el reporte de violación a libertad condicional y los otros documentos que mencionamos?
Sí.
And counsel has filed the following exhibit that is pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement.
La defensa sometió la siguiente evidencia, la evidencia número 1, lista de logros bajo libertad condicional.
Do you need to continue sharing containing any additional evidence?
We do not.
No necesitamos continuar esta audiencia para brindar evidencia adicional.
We have no witnesses today.
No tenemos testigos en el día de hoy.
At this time, the state will have an opportunity to call witnesses, present evidence, and speak to any of the evidence submitted. I'm going to swear in Mr. Hutto as well as Mr. Padilla in the event they would like to speak today.
En este momento es el momento de la defensa para llamar a cualquier testigo o testificar acerca de los cargos. La defensa, el oficial Hutto y el señor Padilla van a ser juramentados.
Mr. Padilla and Hutto, please raise your right hand.
Por favor, levantar su mano derecha.
You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God without penalty of perjury?
I do, yes.
Se jura solemnemente y sinceramente afirma, según sea el caso, que la evidencia usted presente en relación a este caso será la verdad, toda la verdad y nada más que la verdad, que así lo ayude Dios o bajo penalidad de perjurio.
Sí.
Right, so Mr. Hutto, P.O. Hutto, if you'd like to speak at this time, you may.
Sure. I'll try to be brief. The evidence in this violation is clear and admitted to by Padilla's own statements. His behaviors mimic his instant offense. It placed the community, public safety, and minors at risk. He's violated multiple conditions of his release, concealed his behaviors by intentionally misleading his CTPSB therapist regarding his behaviors. And he even
Hold on a
drove.
second. Just
Okay.
let her translate.
Yeah. Sorry about that.
Okay.
Entiendo que la evidencia en este caso es clara. Mr. Padilla mismo mencionó esto en declaraciones brindadas. Entiendo que su conducta es un riesgo a la seguridad pública al estar en contacto en menores, además de que mantuvo su localidad escondida.
Mr. Padilla drove the unregistered car he has no license for to the parole office on the day of his remand after spending nearly 6 months on GPS monitoring for driving without a license or insurance. His current end of sentence date is 6/25/2026. Revoking his parole would be an approximate 1 year, 4-month sanction. Doing this wouldn't deprive him of community supervision as he has 15 years of probation to follow.
Mr. Padilla estuvo conduciendo un vehículo de motor sin licencia luego de haber estado 6 meses bajo monitoreo de GPS por estar conduciendo sin licencia. Se recomienda, él tuvo previamente, el 25 de junio del 2000 tuvo una sanción previa y él tiene 5 años a seguir de probatoria.
Just lastly, I would just say revoking his parole would ensure public safety and provide him the opportunity to reflect on his actions and how to be more successful when he re-enters the community on probation.
Entiendo que revocar su libertad condicional le provee una oportunidad para reflexionar acerca de sus acciones y poder terminar su periodo de libertad condicional satisfactoriamente.
Is there anything you'd like to say in regards to just the charges?
No, no, thank you.
Okay.
No tengo nada que decir en relación a los cargos.
Okay, is now defense's opportunity. If you'd like to speak to any evidence submitted at the time?
Other than a lot of the conduct being replicated and just charged different ways, I've got no comment because of submissions and cooperation. I have no comment as to the preponderance standard.
Aparte de que los cargos básicamente son cosas repetitivas, simplemente que ha sido acusado de manera diferente, no tengo más comentarios ya que muchos de estos fueron admitidos bajo testimonio.
Okay, so what I'm next going to announce my findings. So on charge number 1, I do find you violated condition GPS based on evidence provided in support of the charge, exhibits A, E, F, and H.
En el cargo número 1 hago un hallazgo que usted violó la condición de dirección de salida GPS basado en la evidencia provista, específicamente exhibición A, E, F y H.
Charge 2 and 3 are not taken into consideration as no finding was made at the time of the prelim.
El cargo número 3 no se toma en consideración ya que no se halló causa probable en la audiencia preliminar.
On charge 4, I find you violated condition travel based on evidence provided in exhibits A, J, K.
Cargo número 4, encuentro que usted violó la condición de viaje basado en la evidencia provista, exhibición A, J y K.
On charge 5, I find you violated condition no consumption of alcoholic beverages based on evidence provided, which is exhibits A, J, and K.
En el cargo número 5 hago hallazgo de causa probable que usted violó la condición adicional de no consumo de bebidas alcohólicas, exhibición A, J y K.
On charge 6, I find you violated condition mental health eval based on evidence provided for the charge, exhibits A and E.
Cargo número 6, encuentro que usted violó la condición adicional, evaluación de salud mental basado en la evidencia provista, exhibición A y E.
On charge 7, I find you violate condition no contact with minors based on evidence provided, exhibits A, K, J, I.
Cargo número 7, hago un hallazgo de causa que usted violó la condición adicional, no contacto con menores basado en la evidencia provista, exhibición A, K, J, E, I.
On charge 8, I find you violate condition problem sexual behavior treatment based on evidence provided, exhibits A, G, M, K, J, and I.
Al cargo número 8, encuentro que usted violó la condición de tratamiento de PSB basado en la evidencia provista, exhibición A, G, M, K, J, E, I.
That concludes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend.
Con esto concluye la parte de determinación de hechos de esta audiencia. Antes de hacer mi recomendación, su defensa tendrá la oportunidad de hablar sobre sus antecedentes e historia. Luego de que hayan terminado, usted tendrá la misma oportunidad. El propósito de esta parte de la audiencia de revocación es ayudar a determinar qué resultado, qué sanción recomendaré.
Pio Hutto, would you like to make any statements regarding the offender's violation, background, or history at this time?
Sure. I mean, I would just say that this is the offender's first and only time on community supervision, and it clearly, by the evidence, has not been successful. This is the only body of work that we can use to assess his risk to public safety. And again, I would say that and recommend that this discretionary release be revoked so that he can hopefully be more successful on probation and reflect on the choices he's made.
Quería mencionar que esta es la primera y única vez de Mr. Padilla en supervisión en la comunidad y por lo tanto no es evidente que no ha sido satisfactoria. Yo recomiendo que se revoque su libertad condicional para que entonces él pueda tomar este tiempo para reflexionar y tener un periodo satisfactorio cuando esté bajo libertad provisional.
Now the states, counsel, you have to speak at this time.
Yes, the underlying crime occurred when he was 20 years of age. He's now 27. He has significant support from his stepmother as well as a cousin. He graduated from High School He's been working full-time in the past at Walgreens Distribution Center there for about 3 months.
Hold on.
It's okay.
Go ahead.
Mr. Padilla tiene 27 años de edad y recibe su apoyo primario por parte de su madrastra, también de su prima. Mr. Padilla terminó su 4º año en la escuela secundaria de New Britain. Estuvo trabajando en Walgreens.
Worked part-time first shift at FedEx for approximately 5 months. And for nearly 1 year, the time of remand at J&J Tri-State Delivery Service.
Estuvo trabajando en FedEx en tiempo parcial por un periodo de 5 meses. También trabajó a tiempo completo en JJ Tri-State Delivery, en el cual estuvo por aproximadamente 1 año.
Time of remand, he was in phase 2 of CTPSB treatment and also participated in individual therapy at CRT.
Al momento de ir regresar a custodia, estaba en la fase 2 del tratamiento de CTPSB, además de que también estaba en tratamiento terapia individual con CRT.
While incarcerated once weekly on Tuesdays for an hour, he's been participating in problem sexual behavior program.
También mientras ha estado encarcelado, ha estado trabajando estado participando una vez en la semana, los martes, en tratamiento de programas de conducta sexual problemática.
When released, he'd like to be in a halfway house in Hartford.
Al salir le gustaría regresar a un halfway house en Hartford.
He can return to his full-time position at the delivery service in South Windsor.
Él puede regresar a su empleo a tiempo completo de servicio de delivery en South Windsor.
He'd also like to successfully complete the CTPSB program and reestablish services at CRT.
Él también quiere completar satisfactoriamente el tratamiento de CTPSB y también regresar a los servicios de CRT.
He was paroled on June 12, 2023.
Él fue puesto en libertad condicional en junio 12 del 2023.
He was on parole for approximately 19 months.
Estaba en libertad condicional por aproximadamente 19 meses.
This is his first violation.
Esta es su primera violación.
He was cooperative and admitted the violations.
Él fue cooperador y admitió las violaciones.
He's been in jail for 2 months now.
Lleva en prisión por 2 meses ahora.
And throughout that 19 months, he had 1 3.5-hour battery shutdown. That's all.
A través de esos 19 meses solamente tuvo un problema con la batería de su GPS de 3 horas y media.
Despite drinking most of his life, he had 3 beers within that 19 months on 1 occasion.
A pesar de que ha bebido la mayor parte de su vida, él solamente tuvo 3 cervezas en ese periodo de los 19 meses.
14 days into parole, back in 2023, he missed 1 evaluation.
Él solamente en el 2023 no asistió a una evaluación.
We know he's been in treatment, so he was evaluated sometime within the remaining 18 months again.
Él está en tratamiento, por lo tanto, él fue evaluado en algún momento en esos otros 18 meses.
There are absolutely no allegations of illegal activity in this violation.
No hay alegaciones de alguna actividad ilegal en esta violación.
Essentially, the contact is with the 3 children of his girlfriend, and there is absolutely no allegation of any illegality or contact of any sexual nature.
Fue el contacto con los hijos de su novia y no hay ningún tipo de alegación de alguna violación criminal o de algún tipo de acercamiento de naturaleza sexual.
Recommending a year and to revoke him, I believe, is draconian. This is his first violation. No one was physically injured whatsoever. No one was injured whatsoever emotionally. We're going to ask that he be released at the next available date.
Entiendo que una recomendación de 1 año es excesiva. En esta violación no hubo daño físico, no hubo daño emocional. Me gustaría que él pudiera ser puesto nuevamente en libertad condicional a la fecha temprana más próxima.
Thank you.
Anything else from either the state or council?
I would just quickly like to respond to the council's statements. To summarize this violation into a 3-hour shutdown, 3 beers and a mental health evaluation is disingenuous. There's photographic evidence as well as his verbal, transcribed, written statement that he's kissing a minor female while embracing her.
What?
I'll just allow for translation there.
Entiendo, quiero contestar a lo que alega la defensa para, en resumen, que él resume solamente una violación de 3 horas del GPS, el consumir 3 cervezas y el también tener una violación del GPS, entiendo que no es correcta. Hay fotografías y hay declaraciones de él mismo donde dice que le da un beso a una menor.
I would also just add that counsel does not know that no one was injured emotionally nor physically. He's making an assumption there. Sorry, go ahead.
Tampoco la defensa sabe que no hubo nadie que estuvo emocionalmente afectado físicamente, solamente está asumiéndolo.
That's all I have. Thank you.
Thank you.
Just briefly in response, he's not charged with any illegality whatsoever. He was on parole for 19 months. He admitted the conduct. These are the children of his girlfriend. There are absolutely no allegations that he did anything untoward whatsoever or of a sexual nature. Thank you.
Él no está acusado de ningún acto ilegal. Él estuvo en libertad condicional por un periodo de 19 meses. Él admitió estas conductas y no hay ningún tipo de alegación que estos fueron de naturaleza sexual. Gracias.
I'll be right with you with a recommendation if there's no further testimony from either side. All right, so I will put on the record, defender was in the community for about 1 year and 7.5 months before being returned to custody. He is on discretionary parole with an end of sentence date that is 6/25/26 currently. He does have 15 years probation to follow. This is his first violation. He did receive 3 misconducts during this period of supervision. I see no prior releases to the community in the past for our records. So, sorry.
El señor Padilla estuvo bajo supervisión por un periodo aproximado de 1 año y 7 meses en libertad condicional discrecional. Su fecha de culminación de sentencia es el 25 de junio del 2026 y tiene 15 años a seguir de libertad provisional. Esta es su primera violación a la libertad condicional. Solamente tuvo 3 reportes de conducta en el pasado y no tiene ninguna salida previa en supervisión en la comunidad.
The offender did admit to the violations. And I do want to note the offender was under the influence at the time of incident offense and has continued to drink and be around minors in the community.
Él admitió las violaciones, además de que estaba bajo la influencia y admitió haber consumido bebidas alcohólicas y estar cerca de menores mientras estaba en la comunidad.
Based on the testimony and evidence and factors stated, I am going to recommend that parole be revoked, the offender be re-paroled for December 1st, 2025. It's approximate 10-month period of confinement as a sanction. I also recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, operation of motor vehicle, no contact with victim KR
OS, no contact with minors without PO's permission, mental health evaluation and treatment as deemed necessary, and problem sexual behavior treatment.
Basado en el testimonio y la evidencia, recomiendo que su libertad condicional sea revocada con una nueva fecha del 1 de diciembre del 2025, lo cual es un periodo aproximado de 10 meses como sanción. Además, recomiendo las siguientes condiciones: ubicación en halfway house, no consumo de bebidas alcohólicas, no operación de vehículo de motor, no contacto con menor, evaluación de salud mental y tratamiento de conducta sexual problemática.
This leaves the offender approximately 6 months in the community before discharging to probation.
Esto le da a la ofensora aproximadamente un periodo de 6 meses antes de empezar con su supervisión de libertad provisional.
Mr. Padilla, do you understand?
Mr. Padilla, ¿usted entiende esto?
Sí.
Yes.
Okay, so my findings are going to the parole board on April 10th. So you should receive official written decision from the board within a week of April 10th. The board can lessen the sanction, let it stand, or impose a sanction longer than what I have recommended.
Mi hallazgo y recomendaciones se emitirán a la Junta, lo cual va a ser el 10 de abril. Usted recibirá la decisión por escrito aproximadamente una semana después de la audiencia. La Junta puede disminuir la sanción recomendada o pueden imponer una sanción más larga.
If the board decides to impose a sanction longer than what I have recommended, a supplemental hearing would be held. Before the hearing, the board would provide you with written documents specifying the reasons why they may want to exceed my recommendation. During the supplemental hearing, you would have an opportunity to respond to those reasons while in front of the panel.
Si la Junta decide imponer una sanción más larga de lo que es recomendado, usted se llevará a cabo una audiencia suplementaria. Antes de la audiencia, la Junta proporcionará un aviso por escrito que documente las razones por las que podrían querer exceder mi recomendación. Durante la audiencia suplementaria, tendrá la oportunidad de responder a esas razones específicas mientras esté frente a un panel de la Junta.
This concludes revocation hearing. Do you have any questions?
Esto concluye la audiencia de revocación. ¿Tiene alguna pregunta?
Pregunta si eso es lo que me queda a mí de tiempo, un año.
Is that what
¿Qué
I have
pregunta voy a
left?
hacer yo?
A year?
Sir,
I'm wrong with this guy.
sir. So this is a recommendation of 10-month sanction.
Esto es una recomendación de una sanción de 10 meses.
If the board accepts it, you will be released on December 1st.
Si la Junta acepta esta recomendación, entonces usted saldría el 1 de diciembre.
They can lengthen the sanction or they can shorten it or accept it.
Ellos podrían aceptar la recomendación, podrían disminuir la sanción o podrían extenderla.
Call our office on April 11th and we will let you know what the board decided.
Llame a nuestra oficina el 11 de abril para nosotros dejarles saber qué fue lo que decidió la Junta.
Do you have any questions?
Pregunta porque él puso desde que el GPS apagó a la 1 de la mañana, que cheque el teléfono. I was asking right now, so they can check the phone. Que pueden chequear el teléfono de él cuando yo le escribí a él.
Sir, we wanted to know if you had any questions. The hearing is over. Do you have any questions?
Ah, fuck out of here.
How do you translate?
Queremos saber, la audiencia ya culminó, queríamos saber si usted tenía alguna pregunta.
Ninguna.
No.
Okay, you're off that. Hearing's over. Thank you, Pio Ravenko. Have a good day.
Have a good day. You too. Thank you.
Patricia, I think we have misdemeanors next, if I'm not mistaken, so maybe you can talk to her on the side there. Apologize for jumping in like that.
That's all right. Appreciate it. Morning, sir. Can I get your full name, please?
Tyler Rollins?
Middle name Addison?
Yes, ma'am.
Thank you, Mr. Rollins. This is the time set for your initial appearance. I'm seeing you today on a failure to appear misdemeanor shoplifting out of Pima County Justice Court. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. Looks like the offense date is back in January of 2024. I don't have the date of when you failed to appear for court, but there was a bond amount originally issued by the Justice Court judge of $500. I'm going to honor that request by that Justice Court judge. So it's going to be $500, cash or secured. If you do post it, don't have any contact with whatever that business was of the shoplifting. Don't return to that incident location. I'm going to appoint you an attorney, sir, Peter Gutierrez, and your next court date's actually tomorrow at 1 p.m., April 1st at 1 p.m. If you post the bond, it's up to you to make sure you show up. If not, you'll be seen by video and the attorney will be there. If you fail to show to court, a warrant can issue for your arrest. And if you don't know this already, sir, looks like you have a hold from Oro Valley City Court. You have a $750 bond out of Oro Valley for other charges as well. All right, you understand all that, Mr. Rollins?
Yes, ma'am.
Thank you. Your excuse for today.
Thank you.
Morning, sir. Can I get your full name, please?
Joshua Ray Higgins.
Thank you, Mr. Higgins. This is the time set for your initial appearance. I'm seeing you today on some misdemeanor charges out of Green Valley Justice Court for domestic violence, criminal damage, and domestic violence disorderly conduct. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. In certain instances, if you cannot afford one may be appointed for you. So, sir, I am going to release you today on your own promise to appear for your next court date, which is going to be April 3rd at 8:30 a.m. at the Green Valley Justice Court. Conditions do include no drugs, no alcohol, do not commit any acts of domestic violence. Right now, no contact with Scott Clark, the alleged victim. You can go back one time to the shared residence to pick up any personal belongings with police escort. It looks like your friend Madison is okay with you staying with her, so you can stay with her. All right. If you fail to appear for court, sir, warrant can issue for your arrest. Trial can go without you. Understand all that?
Yes.
Okay. Thank you. You're excused for today.
Thank you. Bye.
Morning, sir. Can I get your full name, please?
Jesse Daniel Mentor.
Thank you, Mr. Mejivar. This is the time set for your initial appearance. I'm seeing you today on a misdemeanor charge out of Pima County Justice Court for criminal trespass in the 3rd degree. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. Mr. Mejivar, today I am going to release you on your own promise to appear for the next court date. Conditions include just don't return to, I guess it was the jail parking lot where this happened. So once you're released, don't come back unless you have some legitimate purpose. All right, next court date is going to be April 10th at 8:30 a.m. at the Pima County Justice Court. If you fail to appear for court, a warrant can issue for your arrest. Understand all that, sir?
Yes, ma'am.
Thank you. Your excuse for today. All right, good morning, sir. Can I get your full name, please?
Jose Montijo.
You have a middle name, Isaac?
Yes.
And are you the second?
Yes, Your Honor.
Thank you. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. So, Mr. Montijo, this is the time set for your initial appearance. I'm seeing you today on a misdemeanor charge of domestic violence, disorderly conduct. If I release you today, do you have somewhere you can go that is not with Myrna McAloon? Is there somewhere else you can stay?
Yes, Your Honor. I have family. My mother.
Okay, and did she live in Pima County, your mom?
No, it's sure. I also have a condo right down the street.
Okay.
On Golf Links, 76.
You have another property that you can stay at on Golf Links?
Yes.
Okay. All right, I am going to release you today on your own promise to appear at the next court date. Stay at that alternate address. Do not have any contact with Myrna McAloon at this time. Don't try to go find her or anything. You can go back to the shared residence with police escort to pick up personal belongings. And do not commit any further acts of domestic violence. Your next court date, sir, is going to be April 30th at 10 a.m. at the Marana City Court. When you're released from custody today, you'll get a sheet of paper with the date and all that and the address. If you fail to appear for court, a warrant can issue for your arrest. Understand all that?
Yes, Your Honor.
All right, thank you, sir. Your excuse for today, Mr. Montijo.
Palacio.
Morning, ma'am. Can I get your full name, please?
Teresa Kathleen Palacio.
Thank you, Ms. Palacio. This is the time set for your initial appearance. I'm seeing you today on 2 misdemeanor charges for domestic violence assault and domestic violence disorderly conduct. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you.
Okay.
All right. I'm going to release you today, ma'am, on your own promise to appear for the next court date. Conditions include do not commit any further acts of domestic violence. Do not have any contact with Leonard Chadwick. He doesn't want to have any contact with you, so no contact with him. Don't try to go find him at his work or his house or anything like that. And your next court day, ma'am, is going to be April 10th at 10:30 a.m. at the Pima County Justice Court. You'll get a sheet of paper with the date and time when you get released this morning. If you fail to appear for court, a warrant can issue for your arrest. You understand all that, ma'am?
Yes.
Yes, go ahead.
Should I let you know right now I'm at SMI, or do I let them know that when I go to court?
Tell the judge when you see them next month.
Okay. Okay.
Thank you.
Thank you. You have a good day, yeah.
Yeah.
Morning. Can I get your full name, please?
Lydia Pintilli.
A middle name, Beatrice?
Yeah.
Thank you. All right, ma'am. This is the time for your initial appearance. I'm seeing you today for 3 separate cases, looks like. You have a failure to appear shoplifting out of Pima County Justice Court. You also have a failure to appear, possession of drug paraphernalia out of Marana City Court. And you also have Tucson City Court charges. These ones are new for crim trespass in the 3rd degree and possession of drug paraphernalia. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. For the Marana City Court case, ma'am, looks like the warrant that was originally issued had an amount of $350. And actually, it's for drug paraphernalia and crim trespass. All right, so that $350 amount that previous judge issued, I'm going to honor that amount. So your release conditions for the Marana City Court will be $350, bond, cash, or secured.
Wait, I need a bond to be released?
Yes, because you failed to show up to court, ma'am. In this, I don't know what the date is, but you failed to show up.
If I fail to show up to court.
Sorry?
So I won't need a bond today to be released, but if I fail to show up to court again?
No, you've already failed to show up to court in Marana City Court, so I'm going to impose a bond.
Okay.
All right, so that's $350 for Marana City Court. I'm going to give you an attorney. Her name is Janet Altschuler. Your next court date's actually this afternoon at 12 p.m. for that. You'll be seen by video, and Ms. Altschuler will be there.
Okay, so it'll be at, the $350 will be at 12?
Yes.
Okay.
All right, and no drugs, no alcohol. Those are the conditions if you do post that bond or if you're released. For the Pima County Justice Court.
Fucked up.
Okay, that one, the bond amount the judge issued was $50, so I'm going to honor that amount as well. That's $50 for the Justice Court one for the shoplifting, cash or secured. The only condition is don't go to the incident location. That one, your next court date is April 1st. That's tomorrow at 1 p.m. Again, you'll be seen by video. I'm appointing Peter Gutierrez to represent you. That's your attorney for tomorrow in Pima County Justice Court. And then for your city court cases, ma'am, these are new charges. Oh, no. Sorry, they're not new charges. They've had before. Okay. All right, they happened earlier in March. All right, these are not new charges. All right, so for the crim trespass and drug paraphernalia, the release conditions, I'm going to release you on your own promise to appear for those ones. So no bond on the city court case. I'm going to appoint you an attorney, though, Tucson City Public Defender, because you're being held on the other matters. The condition includes don't go to the incident location of wherever the trespass happened. And no drugs, no alcohol. Okay. And your next court date for Tucson City Court will be June 6th at 9 a.m. If you fail to show up for court, a warrant can issue for your arrest. You understand all that, ma'am?
Yeah.
Okay, thank you. You're excused for today. Morning, can I get your full name, please?
Eric Stephen Romero.
Thank you, Mr. Romero. Is it hyphenated, Romero Paul?
Yeah.
Thank you. Sir, this is the time set for your initial appearance. I'm seeing you today on some misdemeanor charges out of Pima County Justice Court for domestic violence, disorderly conduct, assault. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. So, sir, looks like the listed victim in this case is Gabriel Godoy. Is that your roommate?
Yes.
And you live at that shared residence with also your girlfriend and your child?
Yes.
So, sir, I'm going to release you today on your own promise to appear at your next court date. Conditions include no drugs, no alcohol, no acts of domestic violence. Gabriel Godoy at this time, he's not, I'm going to order that he not be returning there. So you can stay there with your girlfriend and your child. He can't go there right now, okay? But he can come back to pick up any property or anything like that. But otherwise, he's not allowed to stay there. Unless, are you okay with contact with him?
Yes.
Okay.
Yeah, I'm cool with Gabriel. He's okay.
Okay. So I'll hold off on this. I'm going to see him later this morning. If he's okay with contact with you as well, then you guys can all go back together. If he says, no, I don't want to have contact with Eric, then he can come back one time to pick up his property, but otherwise you'll stay there. All right, so your next court date will be April 10th at 10:30 a.m. At the Pima County Justice Court. If you fail to appear, warrant can issue for your arrest. You understand all that?
Yes, ma'am.
Thank you. You're excused for today, sir. Thank you. Morning. Can I get your full name, please?
Fatima Jennifer Reese.
Thank you. Ms. Reese, this is the time set for your initial appearance. I'm seeing you today for some misdemeanors for driving on a suspended license out of Ajo Justice Court. And looks like there's 2 separate charges for that. Oh, and one is from Hacienda Justice Court. So you have a driving out suspended license for Ajo and then also from Hacienda Justice Court. All right, you have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one, one may be appointed for you. So ma'am, I'm going to release you today on both cases on your own promise to appear for your next court date. Conditions include do not drive without a valid driver's license and show up to all court hearings. For the Hacienda Justice Court case, the next date is April 22nd at 9 a.m. and that's in Wickenburg. So you'll have to contact them. If you can't make it there, you'll have to contact them to figure out if you can appear over the phone or video or something like that. And then for the local, for Ajo, next court date is April 22nd at 9 a.m. at the Ajo Justice Court. Same thing, if you can't make it there, you need to call them to figure out if you can appear somehow by video or change the date or something like that. All right, if you fail to appear, warrant can issue for your arrest. You understand all that, ma'am?
Yes.
All right, thank you. You're excused for today. I didn't. Morning, sir. Can I get your full name, please?
My name is Alfredo Carrillo.
Thank you, Mr. Carrillo. And you have a middle name?
Ricardo.
Ricardo, thank you. So this the time to set for your initial appearance, I'm seeing today on a charge of criminal damage, which is domestic violence misdemeanor out of Tucson City Court. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one, one may be appointed for you. All right, sir. So I am going to release you today on your own promise to appear for your next court date. Conditions include do not commit any further acts of domestic violence and no contact with your sister, Yvette Gutierrez. And don't try to go find her. Don't go to her house, anything like that. All right, your next court date, sir, is going to be on May 5th at 9:30 a.m. at the Tucson City Court. If you fail to appear, warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence and you're not able to be sentenced within 90 days because you're on warrant status, you may lose your right to a direct appeal. Do you understand the consequences of failing to show to court, sir? All right, thank you. And Mr. Carrillo, this is also the time set for your arraignment, so I'm going to enter not guilty pleas on your behalf. All right, you're excused for today, sir. Thank you.
Thanks. Bruce. Your Honor, the Assistant Judge, I'd like to advise you that Ms. Reese has a martial hold at this time.
Ms. Cruz has a martial hold?
Yes.
Thank you.
So away.
Okay, ma'am. Can I get your full name, please?
Liliani Cruz.
A middle name, Anik? All right, thank you. Ma'am, this is the time set for your initial appearance. I'm seeing you today on some misdemeanor charges out of Tucson City Court for disorderly conduct, domestic violence, assault, domestic violence, and criminal damage, domestic violence. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. I'm actually going to appoint the Tucson City Public Defender's Office to represent you in this case. And as the jail just said, you have a federal hold at this time. So if you post any bond, the feds will come and take you. So I'm going to impose a bond of $50 cash in this case, because if we don't have that bond, they're just going to take you, won't be able to resolve your city court charges. So just so you know, ma'am, if you do post that bond, you're probably not going to get released because the marshals will take you for whatever you're facing over there. Conditions include do not commit any acts of domestic violence, do not have any contact with Anik Mejia or Martin Mejia, don't go to their residence or anything like that. Your next court date, ma'am, is going to be April 8th at 1:45 p.m. That's next week. If you fail to show to court, a warrant can issue for your arrest. If you're still in custody, the jail will make sure you get seen and you'll have an attorney there. If you fail to show up to court, a warrant can issue. Trial can go without you. If you're convicted at a trial in your absence and not able to be sentenced within 90 days because you're on warrant status, you may lose your right to a direct appeal. Do you understand the consequences of failing to show to court, Miss Bruce? All right, thank you. And this is also the time set for your arraignment. I'm going to enter not guilty pleas on your behalf. All right, thank you, Ms. Cruz. Your excuse for today.
Cruz. Out that way. Duran.
Morning, can I get your full name, please?
Jean-Marie Duran.
Duran, this is the time set for your initial appearance. I'm seeing you today on some failures to appear out of Tucson City Court for shoplifting, theft, criminal trespass, disorderly conduct, drug paraphernalia, and another theft. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. I'm going to appoint the Tucson City Public Defender's Office to represent you. Looks like you are also in custody on some felony charges. Okay. Oh. I see a $10,000 bond for the Superior Court case. All right, so I'm not seeing you on that today. I'm just seeing you on the Tucson City Court cases. I'm going to propose a bond of $500 cash or secured because there are a number of FTAs in the city court case. If you do post it, ma'am, no drugs, no alcohol, no contact with don't try to go to the incident locations, any of the businesses of the shoplifting or the thefts. Your next court date will be April 8th, that's next week at 1:45 p.m. If you're still in custody, the jail will make sure you get seen by video. You understand that, ma'am?
Yes.
Thank you. Your excuse for today, Mr. Ram. All right, good morning. Can I get your full name, please?
Christopher Thomas Ifa.
Thank you, Mr. Ifa. This is the time set for your initial appearance. I'm seeing you today on some misdemeanor charges out of Tucson City Court for domestic violence, disorderly conduct, domestic violence, criminal damage, domestic violence assault. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. Sir, if I release you today, do you have somewhere you can stay that is not with Mr. Allen? No, you have no friends or family in the area that you can stay that's not with Mr. Allen?
I think I'll check like on their families, but I gotta check with them first.
Okay. All right. I'm sorry, I'm going to release you today on your own promise to appear for your next court date. So you're getting out of jail this morning. Conditions include no drugs, no alcohol, do not commit any acts of domestic violence, no contact with Mr. Allen at this time, and don't go to his house or anything. You can return one time with police escort to get some personal belongings. And you said you're going to check to some places to see where you can stay. Outside the Pima County Jail, there is a transition center. You can stop by there. They do help with kind of temporary housing situations. Sometimes they can get you a phone. So you may want to check that out if you're not able to establish some housing. All right, your next court date, sir, is going to be April 29th at 1:30 p.m. at the Tucson City Court. You'll get a sheet of paper with the date and time and all that when you get released, sir. If you fail to appear for court, a warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence and not able to be sentenced within 90 days because you're on warrant status, you may lose your right to a direct appeal. Do you understand the consequences of failing to show to court, Mr. Ifa?
Yes.
Thank you. And it's also the time set for your arraignment. So I'm going to enter not guilty pleas on your behalf. All right, your excuse for today, sir. Thank you. Morning, sir. Can I get your full name, please?
Thomas Ryan Nischel.
Thank you, Mr.
Nischel.
All right, there we are. Thank you, Mr. Nisha. This is the time set for your initial appearance. I'm seeing you on some failures to appear out of Tucson City Court for criminal damage, domestic violence, disorderly conduct, domestic violence, threatening, intimidating domestic violence. Looks like there's some new city court charges as well. Hold on. And you also have some new city court charges as well, which are alleged to be domestic violence, criminal damage, threatening, intimidating, disorderly conduct, and assault. The failure to appear is from 2022, at least the charges are from 2022. All right, you have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. I'm going to appoint the Tucson City Public Defender's Office to represent you.
I do have something to say though. On the failure to appear, that is wrong. I actually have documentation, Your Honor, that I went to court. I have everything at my home. That's not true. I showed up, I did their steps, I paid $1,500 to you guys. I mean, I have documentation and proof of all of that. So that is not accurate.
Are you talking about Superior Court, sir? This is for...
Yeah, where they said that I didn't show up. I've done everything that they've asked of me. I've showed up. I even had a lawyer too. So that's not accurate or correct, ma'am. But as far as anything else, okay, but I did everything that they asked of me.
I have April 11th, June 13th, and July 21st for failures to appear for the city court case.
Yeah, that's okay. I have documentation, Your Honor. I can prove my innocence on that.
Okay. All right. Well, you can see the judge about that since you say you have some proof for that. All right. So I'm going to impose a bond of $500 because these are old cases. We have to get it taken care of, sir. It's going to be cash or secured. No drugs, no alcohol if you post it. Do not commit any further acts of domestic violence. Looks like there's your wife is okay with. Sorry.
I'm sorry. You said 500. Is it so? With this, the 10% of that is $50 then?
Cash or secured. So cash is 500 flat or secured. So if it's 10%, you can get a bonds company and have some security from them. No contact with Zachary Derrick. Don't try to go find him or anything, but your wife is okay with contact.
Right. Right. Yeah. I mean, he's my son and he lives there with me. I mean, for the past 21 years, I've held the same job and I put motorcycle headsets into the motorcycle officers here in all of Pima County. So I do Tucson Police, I do Pima County Police Officers, I do Cochise County, I do California Highway Patrol. So this is a family business that we've done here in Tucson, 22nd and Cherry, across from the main post office. For the last 47 years, we've been in business with the police officers. We have been in business with them for the past 31 years, and that's what I do. I directly install helmet headsets for the motorcycle officers and take care of them.
Okay, and Mr. Derrick lives at the same house with you and your wife?
Yes, ma'am. His bedroom is right across from mine.
Is he a student?
No, he's not. Nothing. He just works. I guess he's grown. I mean, he's 25, but I mean, he's just a kid. I guess I'm telling you this to ask for the leniency because I can't afford a bond. I can't do that. I'm basically by myself right now. I have no one to contact to do any of that. So if I could get R&R, I have all documentation. I have all proof relaying that I have been to court. I've paid the money. I've done everything that I'm supposed to with an actual lawyer. So I guess that's just it. I'm just trying to ask for some leniency because it's very hard for me to get a hold of anybody to actually try to come up here and get me or any of that. I mean, my wife, she works for the Pima Community College. She's the director of accounting.
Okay,
So it's
thank you,
very,
sir. All right. Thank you for the additional information. I am going to release you today on your own promise to appear for your next court date. All right, conditions are still the same. Do not commit any acts of domestic violence, no drugs, no alcohol. You can go back home.
thank you.
You're going to provide proof of whatever happened in your 2022 counts, whether it was resolved or whether you showed up or whatever happened with it, okay? All right. Your next court date, sir, is going to be April 29th at 1:30 p.m. at the Tucson City Court. If you fail to appear, warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence and not able to be sentenced within 90 days because you're on warrant status, you may lose your right to a direct appeal. And another judge may look at this and say, hey, 2022, and they might not consider what you have to say like I just did right now. Okay, so make sure you show.
Right.
Okay, so I'm not appointing, you're welcome. I'm not appointing an attorney for you because I'm not holding you since you're going to be released today. But of course, you can go hire one if you want to.
Awesome. Thank you so much, Your Honor.
You're welcome. And this is also the time set for your arraignment on the new charges, so I'm going to enter not guilty pleas on your behalf.
Yes, ma'am.
You're excused for today. Thank you.
Thank you again, Your Honor.
You're welcome, sir. Good luck.
Bye.
Morning. Can I get your full name, please?
Louis Allen Pompa.
Thank you, Mr. Pompa. This is the time set for your initial appearance. I'm seeing you today on the new Tucson City Court cases for disorderly conduct and criminal damage, domestic violence. These are misdemeanors. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. I got to set some release conditions for you, sir. I think Miss Janet Martinez is on the line. Ma'am, you got to hit *6 to be unmuted. Hello, Miss Martinez?
Hello?
Yes, did you want to be heard on release?
Yes, I don't feel threatened by him. It was just at the moment, I didn't know what was going on with him, but I want him to come home.
Okay. Thank you, ma'am. All right, Mr. Pompa.
Thank you.
Thank you, Ms. Martinez. All right, Mr. Pompa, you heard what she had to say?
Yeah.
Okay. All right. These are serious charges, sir, but she is okay with you coming home right now, and she's okay with contact at this time. So I will honor her request at this time. All right. You are going to be released on your own promise to appear for your next court date. Conditions include no drugs, no alcohol. Do not commit any further acts of domestic violence. If something else happens and she feels threatened, she calls the police and you're in front of another judge again, you might not be able to get out again. All right. So just be careful. All right. Okay. Your next court date, sir, is going to be April 29th at 1:30 p.m. at the Tucson City Court. You'll get a sheet of paper when you get released today with the date and time. If you fail to appear for court, a warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence and not able to be sentenced within 90 days because you're on warrant status, you may lose your right to a direct appeal. You understand the consequences of failing to show to court, sir?
Yeah.
All right. Sorry?
What?
April 29th is a Tuesday. Okay, and for whatever reason, if you can't show up that day, or call them and let them know in advance so they can move your day. Sure. Okay. Yeah, just make sure you call them in advance if you have to change the date or the time or what have you. All right. And it's also the time set for your arraignment, so I'm going to enter not guilty pleas on your behalf, sir. All right, you're excused for today, Mr. Pompo. He doesn't call. All right, good morning, sir. Can I get your full name, please?
Gabriel. Adam Gabriel.
All right, thank you, Mr. Godoy. All right, so this is the time set for your initial appearance. I'm seeing you today on some misdemeanor charges out of Pima County Justice Court for disorderly conduct, 2 charges, domestic violence and assault domestic violence. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. So the listed victim in this case looks like it's your roommate, Eric Romero Paul. Do you wish to have continued contact with Mr. Romero Paul?
Yeah.
Okay, you want to go back and you're okay with staying with him and his girlfriend and all that?
Yeah.
Okay. All right, so I'm going to release you on your own promise to appear for your next court date, sir. You can go back home. You can have contact with Mr. Romero Paul. He's okay with you having contact with him as well. He's okay with you coming back home. All right.
Yesterday we were all drinking, so I don't even remember what happened. So I have to apologize to Mr. Rivera.
All right, no drugs, no alcohol while the case is pending, sir. No acts of domestic violence, all right? Your next court date will be April 10th at 10:30 a.m. If you fail to appear for court, a warrant can issue for your arrest. You'll get a sheet of paper with the date and time and the address and all that when you get released today. You understand all that, sir?
I understand.
All right, thank you. You're excused for today, Mr. Godoy.
Thank you. Actually, I'd like to show you guys. Wow.
Hey, just putting the key type right up here. That right. You just keep it.
Morning, can I get your full name, please?
Ryan O'Donovan Watkins.
Thank you, Mr. Watkins. This is the time set for your initial appearance. I'm seeing you today on misdemeanor charges out of Green Valley Justice Court for domestic violence, disorderly conduct, and domestic violence threatening and intimidating. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. Okay. If I release you today, sir, is there somewhere you can go that is not with Cherry Dotson?
Yes.
Okay. And where is that?
I go to my sponsor's house.
Is that in Pima County?
I'm sorry?
Is that in Pima County?
Yes, ma'am.
Okay. All right. I'm going to release you today on your own promise to appear for your next court date. Please stay at that alternate address. You can go back at the shared residence with your roommates to pick up any personal belongings with police escort. But otherwise, don't have any contact with Cherry Dotson. Don't go to her house other than that one time to pick up belongings with police escort. Other conditions include no drugs, no alcohol. Do not commit any acts of domestic violence. Your next court date, sir, is April 3rd. That's next week at 8. Is that next week? Sorry, it's this Thursday, April 3rd at 8:30 a.m. If you fail to appear for court, a warrant can issue for your arrest. If for some reason you can't make it, call them and let them know to reschedule your date.
Yes, ma'am.
All right, you understand all that, Mr. Watkins?
Yes, Your Honor.
Thank you. You're excused for today, sir.
Thank you.
At the jail, if you can hear me, are we going to be seeing Mr. Nicholas Galarza?
He was a post release, Your Honor.
Sorry?
He was a post release.
Oh, okay. Thank you.
Man.
I'm assuming the posted is gone. All right, thank you for your patience, sir. Can I get your full name?
Danny Correa.
Thank you. Mr. Correa, this is the time set for your initial appearance. I'm seeing today on new felony charges for possession of narcotic drugs, possession of dangerous drugs, possession of drug paraphernalia. Also a Tucson City Court charge, a misdemeanor for obstruction, refusing to provide a true name. And I'm not seeing you on this, sir, but it looks like you had another case pending out of Pima County Superior Court post-indictment. All right, you have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. For the new felony matter, I'm appointing the Pima County Public Defender's Office to represent you. For the Tucson City Court case, I'll appoint the Tucson City Public Defender's Office. All right. I got to set some release conditions for you, sir. I've reviewed the interim complaint, the pretrial services report, and the state's written recommendation. Looks like $5,000 in lieu of a no bond request. Mr. Goodman, is that correct?
That is correct, Your Honor. As you noted, he's pending similar charges in Superior Court. He'll be seen on, and I'm the county attorney who screens the individuals for steps, and he wouldn't qualify. So we're just asking for a bond and a 10-day PH date.
All right, thank you. Counsel?
Your Honor, we would be asking for a nominal bond. These are drug charges. He is being held without bond in the other case, so I don't think that a large bond in this case would do much.
All right, thank you. I'm going to impose a bond of $1,500, cash or secured, released to pretrial if posted. Mr. Correa, if you do post that bond, no drugs, no alcohol, no firearms, monitoring treatment as directed by pretrial. Your next court date will be a preliminary hearing on April 10th at 1:30. That date may or may not go. So just keep in contact with your attorney. If you fail to appear for court, whether it's that date or any future dates, a warrant can issue for your arrest. Understand all that, sir?
Good.
All right, thank you. And for your Tucson City Court case, sir, I'm going to release you on your... Hold on, Mr. Correa, I'm not done yet. All right, you also have a Tucson City Court case, sir, for that refusal to provide a true name. That one I am going to release you on your own promise to appear, but you're being held in custody on other matters, so I'm going to be appointing the Tucson City Public Defender's Office to represent you. There's no special terms for this case. The next court date will be June 6th at 9 a.m. at the Tucson City Court. All right, now you're excused, sir. Thank you.
Yeah.
Morning, can I get your full name, please?
Luis Garcia.
Luis Enrique Garcia Herrera?
Yes.
All right, thank you, sir. This is the time set for your initial appearance. I'm seeing you on some felony charges, burglary in the first degree and possession of burglary tools. Counsel and Mr. Goodman, I did not find probable cause for burglary in the first degree. Did not see any allegation of a weapon or dangerous instrument, so I'll be dismissing that charge. But there is a felony of possession of burglary tools. There's definitely evidence of a lesser if one were to be charged later. All right, so you have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. I'm appointing the Pima County Public Defender's Office to represent you. So I set some release conditions for you, sir. I reviewed the interim complaint. The pretrial services report. The state's written recommendation is $5,000. Mr. Goodman, did you want to be heard further?
Yeah, Judge, so the structure, I don't think the structure is at issue. I believe you mentioned the weapon. That's what a Leatherman tool is. It's a wrench that has knives on it. So that's what would be essentially a weapon, because that's what a Leatherman tool is. It's a wrench that has, or pliers that has knives on it and things of that nature. But regardless, Judge, he didn't decline to participate in the pretrial services interview, doesn't have a known residence, has a failure to appear history. So we're requesting a bond with pretrial services.
All right, thank you. Counsel?
Your Honor, we would be asking release to pretrial services. This is a nonviolent offense, although he does have some priors. They're over they're like 10 years old. So we would be asking for release to pretrial.
All right, thank you. I do think a bond is appropriate in this matter and can impose a bond of $4,000, cash or secured, released to pretrial if posted. No drugs, no alcohol, no firearms, monitoring treatment as directed. No contact with the alleged victim. Do not go to the incident location wherever you're arrested, sir. Your next court date will be April 10th at 1:30 for a preliminary hearing. That date may or may not go, so please keep in contact with your attorney. If you fail to appear for court, a warrant can issue for your arrest. Do you understand all that, Mr. Garcia Herrera?
Yes.
And my apologies, Your Honor. Did you say the public defenders is appointed in this?
Yes.
Thank you.
Thank you. You're excused for today, sir.
Let's put the bond. That's your next court hearing. Contact your attorney at this number.
Okay. Do I go now? Okay.
All right, good morning, sir. Can I get your full name, please?
Raul.
You, Mr. Labrador Velarde. This is the time set for your initial appearance on a charge of possession of narcotic drugs, which is a felony offense. Mr. Goodman, I see you, the state's pretrial or initial appearance recommendation is motion to dismiss without prejudice.
Correct, Your
Honor. Okay.
Objection.
Thank you. So, sir, the state is moving to dismiss. I will grant that request. Order dismissing this matter without prejudice, sir. You'll be released from custody today.
Thank you, Your Honor.
Clear.
Morning, sir. Can I get your full name, please?
Stephen McClure.
Thank you, Mr. McClure. This is the time set for your initial appearance. I'm seeing you today on a charge of possession of dangerous drugs, which is a felony. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. I'm going to set some release conditions for you, sir. I review the pretrial services report, the interim complaint. The state's written recommendation is a $5,000 bond in lieu of no bond and potentially steps eligible. Mr. Goodman, did you want to be heard further?
Judge, this is primarily due to him being on release and warrant status for his existing matter. Even though I'm requesting a bond, he is somebody that I would consider for the STEPS program, so we can definitely set a STEPS hearing as well.
Okay, and so since you said you were the prosecutor assigned to review for STEPS eligibility, it looks like the prior case you mentioned was on warrant status. Mr. McClure was enrolled in STEPS but removed from STEPS. Is that a bar?
No, not necessarily. But I did confirm and look through his other, I call it criminal history, like into his misdemeanor history. So what would happen typically, you would, if you held him, set the 10-day PH date with a STEPS hearing. But I did double check, and he is somebody who I would likely give another chance at the STEPS program in this current case.
Okay, thank you. All right, counsel?
Your Honor, just one question with regarding probable cause in this case. I did notice from the complaint there was mention that there was meth in the pocket. I didn't see anything with regards to the whatever the item was having been tested.
I see a handwritten positive for meth in a, I don't know if that's the date or ID number. That must be the ID number of the officer. Yes, there's an officer number there. It's handwritten at the bottom.
Thank you, Your Honor. So, Your Honor, with regards to what the state has indicated that this would be a STEPS eligible case, we would ask for a nominal bond.
All right, Mr. McClure, you previously participated in STEPS. Would you be interested in trying for it again?
Yes.
Okay.
Definitely. Can I mention something?
Not right now.
Okay.
Okay. Pose a nominal bond of $500, cash or secured, released to pretrial if posted. No drugs, no alcohol, no firearms, monitoring treatment as directed. Do not go to the incident location. Steps hearing will be April 7th at 9 a.m. That's next Monday, sir. If you post your bond, you got to make sure you show up next Monday. Otherwise, they're not going to consider you. But similar to the prior case, they're going to screen you to see if you'll be eligible for that date. And then the preliminary hearing date will be April 10th at 1:30 p.m. As you know from your other case, sir, if you fail to appear for court, a warrant can issue for your arrest. Understand all that?
Yes.
Your Honor, may I have the steps date again?
April 7th, next Monday at 9 a.m.
Thank you, Your Honor.
Thank you. All right, sir, excused for today.
Luis.
Morning, sir. Can I get your full name, please?
John Reese Rascon Jr.
It's Ruiz Rascon.
Yeah, RUIZ Rascon.
Thank you. So this is the time set for your initial appearance. I'm seeing you today on a felony charge of unlawful flight from law enforcement vehicle and also some misdemeanors for criminal damage and reckless driving. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. I'm going to be appointing the Pima County Public Defender's Office to represent you. I got to set some release conditions for you, Mr. Ruiz Rascon. I've reviewed the interim complaint, the pretrial services report, and the state's written recommendation is released to pretrial. Is that correct, Mr. Goodman?
That's correct, based on the pretrial risk assessment of him and the lack of history.
All right, thank you. Counsel?
I would ask for a release as well, Your Honor, to pretrial services.
Okay, thank you. All right, sir, I'm going to release you to pretrial services. Conditions include do not drive without a valid driver's license, no drugs, no alcohol, no firearms, monitoring treatment as directed by pretrial, no contact with any of the alleged victims in the case. Your next court date, sir, is a preliminary hearing on April 21st at 1:30 p.m. That date may or may not go, so please keep in contact with your attorney. If you fail to appear for court, a warrant can issue for your arrest. You understand all that, Mr. Ruiz Rascon?
Yes, ma'am.
All right, thank you, sir. You're excused for today.
Contact your attorney here, and when you can call this number.
Being released.
Yes.
Honey.
Yes, they'll call pretrial services.
All right, thank you. Hutto.
Sir, good morning, sir. Can I get your full name, please?
Paroles says Hutto.
Thank you, Mr. Soto. This is the time set for your initial appearance. I'm seeing you today on a felony matter of criminal damage of tampering with a utility. I'm also seeing you on some Tucson City Court charges for domestic violence, disorderly conduct, criminal trespass, disorderly conduct, interference with judicial proceedings, resisting arrest, and you also have a failure to appear out of Tucson City Court for assault. And I'm not seeing you on this, sir, but it looks like you have a Pima County Justice Court case that is also ongoing. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. For the felony matter, I'm appointing the Pima County Public Defender's Office to represent you. For the city court matter, I'm appointing the Tucson City Public Defender's Office to represent you. I set some release conditions for you, sir. We'll talk about the felony matter first. I've reviewed the interim complaint, the pretrial services report, and the state's written recommendation. Mr. Goodman, I see $10,000. Anything else you'd like to add?
Just that he was uncooperative, couldn't be interviewed. He's maxed out on all their scales on pretrial. Not only does he have the violent felony prior. He also appears to have a violent misdemeanor history as well.
Right, thank you. Counsel?
Your Honor, we'd be asking for a lower bond, about $2,500 in this case. Mr. Soto doesn't have the funds to be able to pay it, so we're asking that it be reasonable. He does have housing. Mr. Soto also indicated that in this case, I guess he was brought to the jail, then taken to the hospital and released from there, so he had been released before. So for those reasons, we're asking for a lower bond.
I'm going to pose a bond of $5,000 in the felony matter. Cash or secured. Released to pretrial if posted. No drugs, no alcohol, sir. No firearms. Monitoring treatment as directed by pretrial. No contact with the alleged victim. Don't go to the incident location. Your next court date for the felony matter, sir, will be April 10th at 1:30 for preliminary hearing. That date may or may not go, so please keep in contact with your attorney. If you fail to appear, warrant can issue for your arrest. And also, please abide by all conditions of the active order of protection that you have right now. And then for the Tucson City Court cases, sir, I am also going to impose a bond. All right, so on the city court case, it's going to be $1,000 cash or secured. No drugs, no alcohol. Do not commit any acts of domestic violence. No contact whatsoever with the named victim who has an active order of protection against you, sir. Don't go to his house. Don't try to find him, anything like that. There's other terms of the active order of protection. All right, your next court date for Tucson City will be April 8th. That's next week at 1:45 p.m. in front of Judge Rivera. If you appear after you post all the bonds, a warrant can issue for your arrest. Trial can go without you. If you're convicted at a trial in your absence and not able to be sentenced within 90 days because you're on warrant status, you may lose your right to reject appeal. Do you understand the consequences of failing to show to court, sir?
From here, spoke to him, and he released me. No bond or nothing, and now I let the judge know. Like this, that bribe last night was completely unrelated to that. Now they bring a bond charge for that, and I don't understand why.
Sir, you'll have a chance to ask counsel questions in a bit. I have a question for you. Do you understand the consequences of failing to show to court, sir?
I didn't.
Okay, all right. This is also the time set for your arraignment on Tucson City Courts. I'll enter not guilty pleas on your behalf. All right, you're excused for today. You can ask any other questions you may have to counsel.
Yeah. Yesterday, when this matter of the accident occurred, they didn't mention bond nothing.
Morning, sir. Can I get your full name, please?
Bryson Yance?
Thank you. Is your middle name Daniel?
Yeah.
Thank you, Mr. Yance. This is the time set for your initial appearance. I'm seeing you today on new felony charges for possession of dangerous drugs, possession of drug paraphernalia. You also have a new city court case for shoplifting misdemeanor and some failures to appear out of city court for criminal trespass. Those are alleged to have occurred in 2024. You have the right to remain silent. Anything you say can be used against you. You have the right to hire your own attorney. In certain instances, if you cannot afford one may be appointed for you. Or your Pima County felony case, I'm appointing the Pima County Public Defender's Office to represent you. I gotta set some release conditions for you, sir. I've reviewed the interim complaint, the pretrial services report. The state's written recommendation is release to pretrial and potential steps court hearing. Mr. Goodman, is that all correct?
That's correct, Your Honor. I had some concerns given the misdemeanor failures to appear, but he doesn't seem to have a concerning history. That's why the state was fine with pretrial potentially.
All right, thank you, counsel.
We would also ask for a release to pretrial services, Your Honor.
Okay, thank you. All right, Mr. Yance, would you be interested in potentially participating in a substance abuse diversion program? So the state has a diversion program. It's pre-indictment that would help with substance abuse counseling and treatment for drug abuse. Would you be interested in participating in that program?
Sure.
Okay. All right, so they do a screening, sir. You'll put you in steps, and the steps hearing is next Monday at 9 a.m. They do a screening to see if you qualify for it. So you show up to Superior Court next Monday at 9 a.m. to see if you can actually participate in the program. I am going to release you pretrial services. Counsel waive time for the PH date.
Yes, Your Honor.
So the preliminary hearing date will be moved out to May 15th at 1:30 p.m. Conditions of your release to pretrial, sir, include no drugs, no alcohol, no firearms, monitoring and treatment as directed by pretrial. If you fail to show to court next Monday, sir, they're not going to consider you. So just make sure you show up next Monday to find out if you can participate in this substance abuse program. If you fail to show to court, a warrant can issue for your arrest. Do you understand all that, sir?
Yeah.
Okay. All right. And then on your city court cases, sir, I'm going to release you on your own promise to appear. Got to show up to Tucson City Court on May 5th at 9:30 a.m. Conditions include do not have any contact with any of the business victims listed in any of the cases. Don't try to go back to the incident location. No drugs, no alcohol. All right. If you fail to show to court, a warrant can issue. Trial can go without you. If you're convicted at a trial in your absence and you're not able to be sentenced within 90 days because you're on warrant status, you may lose your right to a direct appeal. You understand the consequences of failing to show to court, Mr. Younts?
Yes.
All right, thank you, sir. And also, it's a time set for your arraignment on the new charge of theft out of city court. I'll enter not guilty pleas on your behalf. All right, you're excused for today, sir. Thank you.
Quick question, Your Honor. The theft is on 4/7 at 9?
Yes.
Thank you. You need to return when you get out. You need to call them and then get them with your attorney on this.
Okay, I'll call them, like, so I'm getting released today and
They're
then.
going to release, but you need to call them and keep in touch with them.
Okay.
All right, at the jail, is that everyone?
Yes, Your Honor.
All right, thank you. Thank you, counsel. Thank you, Mr.
Thank you.
Goodman.
All rise. Thanks, everyone. Please be seated. Okay, good morning to the three of you. My name is Commissioner Hughes. This is the 11 a.m. initial appearance calendar for Monday, March 31st. The court's orders for the taking of DNA samples and fingerprints issued on the first calendar of March will apply to these hearings. As we get started, I'm going to call each of you into the courtroom one at a time. When I call you into the courtroom, I'll ask you to stand behind this gray podium right here in front of me. First thing I'll do is ask you to state your full name and date of birth. Then I will explain to you why you're here. I will tell you whether you qualify for a court-appointed lawyer, sometimes called a public defender, to represent you. If you do not, or even if you do, you have the right to hire a private lawyer at your own expense to represent you in criminal proceedings if you wish to. After we talk about a lawyer, I will give you the next court hearing dates and times you'll be required to attend after this court hearing. And the last thing we'll do while you're in the courtroom is go over the terms and conditions upon which you may be released from custody. You should all know that in addition to the right to the assistance of counsel, you have the right to remain silent. These are recorded criminal proceedings. That means anything you do choose to say in the courtroom this morning can be used against you at any point down the line in these proceedings. Unless you have made arrangements with a private lawyer, and I don't think any of you have, there will not be a lawyer in the courtroom to defend you this morning. Because you won't have a lawyer in here and because anything you say could be used against you, I will strongly caution all of you not to make any statements regarding the facts about why you're here. Please save any comments, questions, statements about the facts of your case for a hearing where you have a lawyer present to discuss that with before you make any statements on the record you can't take back. Last thing I'll tell you before we get started is that all of the information you get while you're in the courtroom will be contained in a written release order. You will get a copy of that order when you are done in the courtroom and you step back into the room you're in right now. So please keep that paperwork with you wherever you go from here today, because in that paperwork you'll still have all the information you got in the courtroom. All right, can I please have Najee Boston into the courtroom, please? Elizabeth Vargas, you'll be up next. Good morning. Can I please have your name and date of birth?
Najee Rahid Boston, 07-19-1993.
Thank you very much, Mr. Boston. You are here on allegations of new charges. The allegations against you are one count of aggravated assault, that is a felony offense, one count of misdemeanor assault, 2 counts of misdemeanor disorderly conduct, and 1 count of misdemeanor criminal damage. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference April 7th, and then you will have a preliminary hearing April 9th. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. On these allegations, I have imposed a $25,000 secured appearance bond. Secured appearance means that you can use a bonding company to post that bond if you choose to. If you are interested in discussing terms with a bonding company, when you get back into the facility, there's a list of bonding companies and their phone numbers posted in various places. You can find one of those lists and call any of the companies on that list to see what terms they might offer you, to see if anybody can work with your circumstances. If you get that bond posted prior to your release from custody, you will be affixed with an ankle monitor for electronic monitoring. If you post that bond and you are released on the ankle monitor, you are ordered not to return to the scene where the underlying alleged events took place. You cannot have contact, physical or otherwise, with any alleged victims. You are prohibited from possessing any weapons, drugs without a valid prescription, or alcohol if you're released from custody. And whether or not you are released from custody, you are strictly ordered to comply with the terms of any orders of protection or orders against harassment, if any have been or might later be served upon you. Do you understand all of these conditions?
Yes, ma'am. I'm not, I can make bond, but I don't have like my phone and stuff to call the proper people that I need to. Is there any way that you can trust me to make bond? So if I were to leave here and make phone calls so I can bond?
Well, you can't leave until the bond is posted.
Okay.
So the sequence is you have to post the bond and then you will be released. Okay. I don't know who has your phone. I don't know if MCSO has it. I don't know if law enforcement has it, but I don't have any control over what access you have to property like your phone. Yes. I will tell you, if law enforcement has impounded it for evidence, you are not likely to get that back until they release it. If MCSO has it because it was taken when you were booked in here.
Yeah, they said it was here. I'm sorry.
Okay, so you can talk to jail staff. I think the answer is probably you don't get access to that until you are released, but you can confirm that with jail staff. Yes. I don't have control over what property they allow you access to. So if the issue is you don't have any phone numbers without your phone, I would say try and call some bonding companies and see if you can get them to work with you without having to reach out to somebody whose number is stored in your phone.
Okay.
All right. Any other questions?
No, ma'am.
Okay. Thank you.
I do have one more question. So
sure.
If something happens where I can't make bond today, how long am I in? I'm in here for the next court date?
Yes. If you don't post that bond, you stay in custody at least until your first court hearing, which is April 7th.
Okay.
Anything else?
No, ma'am.
All right. Thank you, sir. You can step back and get your paperwork. Elizabeth Vargas, if you would please work your way into the courtroom. Madison Townsend, you will be up next. Can I please have your name and date of birth?
Elizabeth Vargas, 4583.
Thank you very much, Ms. Vargas. You are here on 2 probation violation warrants. In both cases, petitions to revoke your probation have been filed. They both allege that you have violated terms 3 and 5. I have appointed a lawyer for you in both cases. Your next court hearing in these 2 cases will be a revocation arraignment hearing. It will be April 7th at 8:30 in the morning. On each of these 2 warrants, you have a $500 secured appearance bond.
Okay,
that means your total bond will be $1,000. If you post that and you're released, you are ordered not to possess any weapons or drugs without a valid prescription. Do you have questions?
What does that mean?
It means you have to post a bond in order to be eligible for release.
I cleared all these warrants.
Apparently not these 2.
Yeah, I cleared everything.
Well, you'll have to talk to your lawyer. So if you think that there has been some mistake, it looks like these petitions to revoke were filed December 24th. So if you think that there's been some mistake or some underlying issue, you can talk to your lawyer about that either at your next hearing on the 7th or in your release order, you have the phone number to the public defender's office. But it looks like as of December 24th, these warrants were issued, and as of today, they remain valid warrants. Any other questions?
I don't understand what these warrants are for.
They're for allegedly violating the terms of your probation.
Those got I didn't even do anything.
Talk to your lawyer. You can talk to your lawyer about the facts of the case. Go ahead and step back to your left and get your paperwork.
And so I can't go home yet?
Not unless you post that bond.
1,000.
1,000, yep. Okay, Madison Townsend to the podium in the courtroom, please. Oh, I didn't change these. Can I have your name and date of birth, please?
Madison Judith Townsend, October 24, 1999.
Thank you very much. You are here on 2 probation violation allegations. In both of these cases, the allegation is that you have committed term 3 and 5 violations. I have appointed a lawyer to defend you. It looks like you might already be in revocation proceedings for a prior term 1 violation. So you might already have a lawyer on these 2 cases, but if you don't, I have appointed one. So either the lawyer already working with you will stay on your case or you'll get a new one, but in any event, you're entitled to a lawyer. So at your next court hearing, there will be a lawyer there to defend you.
So is it for the failure to appear or is it for the old charges for that was?
Neither. So it looks like there was a term 1 violation filed in both cases. And then a warrant was issued when you failed to appear at the revocation arraignment or maybe the non-witness violation hearing in that case. So I think you were already seen on the failure to appear warrant. These new violations, the 2 cases that I'm seeing you on are for alleged new violations. So you've got the term 1 violation pending. I'm seeing you on now alleged term 3 and 5 violations. So same 2 probation cases, same proceeding you're already in, but now adult probation is alleging new violations in each case. Did that answer that question?
Yeah.
Okay. All right. So your next court hearing will be April 7th at 8:30. The good news is that's the same date and time as the hearing that was already set. So you've only got to go to court on that one day to hopefully get all of this wrapped up.
Okay.
Okay. On these two new warrants, you have $50 cash bonds on each. So on these two warrants, you have a $100 cash bond. If you do post that and you're released from custody, please make sure you get yourself to the probation court on April 7th. And if you're released while you are on release, you cannot possess any weapons or drugs without a valid prescription. Okay, any questions?
No.
Okay, thank you, Ms. Townsend. You can step back and get your paperwork. Okay, number 2 on the calendar, Wendy Natividad Robles Juarez, date of birth 10/30/2002, is not in the courtroom because she was unable to function in general population due to combative and aggressive behavior. She is here on allegations of new charges. Those allegations are 2 counts of aggravated assault, both class 5 felonies, and 1 count of assault, a class 1 misdemeanor. I have found probable cause to support those allegations and appointed a lawyer to defend her. Her next court hearings will be a status conference April 7th and a preliminary hearing April 9th, both of them at 8:30 in the Superior Court downtown. I have imposed a $15,000 secured appearance bond on these allegations. If she posts that bond, she will be affixed with an ankle monitor prior to her release for electronic monitoring. If anything changes after I visit her cell side, the court's final orders will be reflected in the written release order issued in this matter. That concludes the 11 a.m. initial appearance calendar. This court will now stand in recess until 2 p.m.
Pretrial.
She received $1 bond on her traffic case.
Okay. Good afternoon. For possession with intent to sell cocaine, I will appoint the public defender's office for you. It's only probable cause for possession of cocaine. I'll give her pretrial services with an alternate bond of $2,500 and include her traffic case for pretrial. That's the no valid driver's license, AKGL. Is that I-5E?
Yes.
Okay, so alternate $1. You're gonna have 2 separate court dates. Make sure to keep all future court dates. I believe that concludes our afternoon calendar. Right? Is there anything else, Ms. Bourne?
Thanks, Judge.
Thanks,
Judge.
Nice to have you back. We were in court till like 5 one day last week. I'm so sorry. I'm glad to be back and out of my vacation plan, so I'm good. Take care. See y'all tomorrow. Take care.
AKGL-I-5E.
Yeah, alternate $1.
As a condition of the pretrial release, and no possession of any drugs without a prescription. I am going to appoint the public defender to represent you. Do you have any questions?
Sir.
All right. Good luck to you, sir.
Here you go.
All right, I have Ruben Soto.
Yes, Your Honor.
All right, good afternoon.
Good afternoon.
So I'll be here for initial appearance on two cases. One is a driving license suspended, revoked. So let me double check on these. I read them, but gotta refresh my memory.
And Your Honor, defense was going to argue no PC to the possession of MDMA. I don't believe that it is mentioned anywhere in the affidavit.
All right, give me a second. I'm going to appoint the public defender on both these. State, I think she's got a good argument on the, let's see, I got the heroin.
Yes, Your Honor. Ms. George brought her argument to my attention prior to court. And I believe she's right. It's not mentioned within the report at all. It does state about the heroin and cannabis and paraphernalia. And then later in the officer's report, it does state I was placed under arrest for Willis, resisting, heroin, cannabis, and paraphernalia. I don't see any additional substances or anything that would give any rise to there being something additional. So this time state's not requesting additional 24 hours.
Okay.
We just asked for an ROR on 2.
Okay. So I'll find PC on 1, no PC and ROR on 2, PC on 3, 4, 5. Leave the bond amounts as is on the arrest affidavit. Adopt those. And set the bond at 500 on the duelist case, on the CT. Order no possession of any drugs without prescription. No weapons or firearms. State, any other requests?
500 times 4. Thank you. No, Your Honor.
Okay, all right. All right, sir, so I set a bond for you on each of those. It's 25, 35, 4, it's about 4,500, 5 grand, something like that is your bond. And appointed you an attorney. That's all I can do for you for today. Good luck.
Your Honor.
Thaddeus Thomas.
Yes, sir.
All right, good afternoon. Have you here for battery on a uniform licensed security officer, disorderly conduct, and possession of cannabis. All right, finding probable cause for the arrest. Set the bond at 2,500 on count 1. 250 on 2 and 500 on 3. Order no possession of any drugs without a prescription. Order no return to 39 North Orange Ave. No contact with the victim, Thomas Carson. And appoint the public defender to represent him. Good luck, sir. Tatiana Vera. All right, good afternoon, ma'am. Have you here for possession of drug paraphernalia and possession of cocaine. All right, find probable cause for the arrest. Set the bond at 500 on count 1, 2,500 on count 2. Appoint the public defender to represent her. Order no drugs without a prescription. All right, ma'am, good luck to you. John Welter.
Waive, Your Honor.
All right, fine PC. Order no drugs without prescription. Set the bond at 2,500. Appoint the PD to represent him. All right, Edgar White.
Yes, sir.
All right, good afternoon.
Good afternoon.
So have you here for initial appearance charged with tampering with physical evidence, possession of cocaine with intent to sell, possession of cannabis with intent to sell, and possession of drug paraphernalia. State bond on count 2.
The schedule is usually about 15,000, depending on the history. Sometimes that is halved. The schedule's 15.
I see past arrest for possession of cocaine.
Your Honor, he was also very forthcoming with law enforcement. State would just also absolutely take that into account when setting his bond. After Miranda, he did elect to speak.
All right, any objection for 7,500 then?
No, Your Honor.
All right, so we're gonna set your bond at 2,500 on count 1, find probable cause for each of these. Set your bond on count 2 at 7,500, which is lower than the usual schedule. 2,500 on count 3 and 500 on count 4. Order no possession of any drugs without a prescription. Set the bond, appoint the public defender to represent him. All right, good luck, sir. Demetrius Young.
Waive reading, Your Honor.
That's what I thought. Okay. State, you're asking for no bond in a PTD hearing?
Yes, Your Honor. Count 1 is capital, count 2 is PPL. We are requesting that you hold him no bond pursuant to Arthur. They are both F1s.
Okay. So, sir, what's going on is that due to the nature of the alleged offenses, I'm just the initial appearance judge, so I'm not the one who's going to be hearing this overall. Due to the nature of the offenses, we're not going to read the narrative or anything. The nature of the offenses are call for no bond. So under the law, I'm leaving you held at no bond. But you are going to have another hearing on April the 4th.
April the 4th, 9 a.m., courtroom 7B.
So April the 4th at 9 o'clock, your next hearing, and they'll determine your bond from there. For right now, I'm holding you at no bond under the statute. But I'm going to appoint the public defender to represent you in the meantime, and they can discuss things further with you.
Request no contact with the victim or any other child under the age of 18.
All right, no contact with the victim or witnesses. I had that written on there, State, so thank you for the reminder. And no contact with any kids under the age of 18. right, good luck, sir.
Your Honor. Your Honor, sorry. Can we recall Martinez Dennis from first session? Apparently he has, an alternate address that's out of state, so we were trying to see if he can be allowed to travel to New York.
Yeah, that's fine.
Okay.
All right, we're in recess off the record.
In this case, sir, I'm going to require pretrial release, house arrest with GPS, electronic monitoring, and bail as conditions of pretrial release. Your bail is set at $15,000 on the DUI third or subsequent offense and $5,000 on the refusal to submit charge. You may not be released until the GPS electronic monitor is affixed to your person. Additionally, you are to be under house arrest conditions in pretrial release. You also have to report to pretrial release services office immediately once you're released in person at their office in Bartow. Thereafter, you need to report by phone twice a week on Tuesdays and Thursdays. You may not, I'm sorry. Oh, sorry, it's daily call-in, Sunday through Monday. Additionally, you may not possess or consume any alcohol or enter any bars or lounges. You also must submit to random breath tests that you are required to pay for. Thank you, sir, and good luck to you.
Thank you.
One moment. And right now, the only exception to the house arrest is for court and for your appointments with your attorneys, okay? Did you get it?
No, say it again, please.
Right now, the only exceptions to the house arrest is your appointments with your attorneys and court. Thank you, sir. The next case is Todd Modis.
That's for all.
So you're charged in this case with leaving the scene of a crash involving property damage, giving false info to law enforcement officer during an investigation, and misuse of 911 or E911 system costing over $100 for a response. Would you like for me to appoint the public defender to represent you?
At this time, please.
I originally appointed the public defender to represent you in this case, and I have reviewed the arrest report and the citations, and I do find probable cause for the charges. In this case, sir, I'm going to require pretrial release with bail's condition of pretrial release. Your bail is set at $5,000 on the misuse of 911 or E911 system costing over $100, $1,000 on the giving false ID to a law enforcement officer during investigation, and $250 on the leaving the scene of the crash charge. Once you're released, you need to report to pretrial release services office in Bartow in person immediately. Thereafter, you need to report by phone twice a week on Tuesdays and Thursdays. Thank you, Mr. Modis. Good luck to you.
Thank you.
The next case is Nicholas Carigno. Carigno, you are charged in this case with violation of probation on an underlying felony petty theft charge in case number 2024 CF 980, and apparently a new felony petty theft third or subsequent offense charge. Would you like for me to appoint the public defender to represent you?
Yes.
I originally appointed the public defender to represent you in this case. I have reviewed the arrest reports and I do find probable cause for the charges. As to the alleged violation of probation, because of its nature, you're going to be held no bond on that. But as the new felony petty theft third or subsequent offense charge, I am going to require pretrial release with bail as a condition of pretrial release. Bail is set at $5,500. Once you're released on that charge, you must report to pretrial release services office in Bartow immediately in person. Thereafter, you have to report by phone twice a week on Tuesdays and Thursdays. You're going to have no contact with any Circle K stores. You have to stay at least 500 feet away from the alleged event location of this event as well, okay?
Good.
All right, thank you, sir. Take care.
Yes, ma'am, too.
Next case is Brandon Waters. Mr. Waters, it looks like you are here on alleged violations of probation related to two previous cases, case number 2023 CF 8598 and 2022 CF 6512. Would you like for me to appoint the public defender to represent you on those charges, or are you going to hire your own attorney or represent yourself?
Public defender, please.
Originally appoint the public defender to represent you on those charges, and I have reviewed the violation of probation arrest warrant that was issued, as well as the violation of probation affidavit, and I do find probable cause for all of the charges. But because of their nature, right now, you're going to be held no bond, okay?
Yep.
All right, thank you, sir. Take care. The next case is Jonathan Ramon Iglesias. Sir, you're charged in this case with violation of probation on an underlying charge of burglary of a dwelling from case number 2024 CF 4668. Would you like for me to appoint the public defender to represent you in this case, or are you going to hire your own attorney or represent yourself?
I would like a public defender, Your Honor.
I provisionally appoint the public defender to represent you in this case, and I have reviewed the violation of probation affidavit and warrant that was issued, and the complaint affidavit, and I do find probable cause for all of the charges. Given the nature of the allegations that they're alleged violations of probation, your bond status right now is no bond, so that's the situation. Okay, Mr. Iglesias?
Okay,
All right, thank you, sir.
thank you.
Let's see. I see more people than I have on my list. I probably missed someone. And who else do we have?
Give your name.
Javonte Jenkins,
How do you spell it?
Jovontae.
Jenkins is the last name.
Mr. Jenkins, I'm sorry I missed you. All right, you are charged in this case with possession of firearm as a convicted felon and domestic violence aggravated assault. Would you like for me to appoint the public defender to represent you in this case?
Yes, ma'am.
I provisionally appoint the public defender to represent you in this case, and I have reviewed the arrest report, and I do find probable cause for the charges. In this case, sir, I'm going to require pretrial release with bail as a condition of pretrial release. Your bail is set at $10,000 on the possession of firearm by a convicted felon charge and $5,000 on the domestic violence aggravated assault charge. Once you're released, you need to report to pretrial release services office in Bartow immediately in person, and thereafter you need to report every week by phone 3 times a week on Mondays, Wednesdays, and Fridays. You may not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. And you also must stay at least 500 feet away from the victim's residence, place of employment, vehicle, and schools at all times. You can't have any contact with the victim in any way, shape, or form. Okay, Mr. Jenkins?
Ma'am.
Right,
Hello?
Yes, sir.
I was gonna say we share 2 kids together.
Well, right now you can't have any contact with the victim, but I did appoint the public defender. So if there's a motion they need to file, you can talk to them about it, okay?
Yes,
Figure out
ma'am.
logistically how that's gonna work, okay?
Yes, ma'am.
All right, thank you, sir.
Thank you.
Is there a Yerko Ivalik Carcamo?
Yes, Your
All right.
Honor.
You are charged in this case with knowingly driving while license suspended or revoked. Would you like for me to appoint the public defender to represent you?
I would appreciate it.
I provisionally appoint the public defender to represent you in this case, and I have reviewed the citation and arrest report, and I do find probable cause for the charge. In this case, sir, I'm going to require a pretrial release with bail as a condition of pretrial release. Your bail is set at $250. Once you're released, you need to report to pretrial release services office in Bartow immediately in person, and thereafter you need to report by phone every week, once a week on Mondays. And it goes without saying, but I'll say it anyway, no driving without a valid driver's license, okay?
Yes, ma'am. I can have my wife drive.
All right, thank you, sir. Take care.
Thank you as
Who
well.
else? Who else do we have behind you?
Miller.
Miller
Charles.
Mr. Miller, you're charged in this case with felony petty theft, third or subsequent offense. Would you like for me to appoint the public defender to represent you in this case?
Ma'am.
I couldn't hear you, sir. I'm sorry.
Yes, ma'am.
I provisionally appoint the public defender to represent you in this case, and I have reviewed the arrest report, and I do find probable cause for the charge. Mr. Miller, I'm going to require a pretrial release with bail as a condition of pretrial release. Your bail is set at $7,500. Once you are released, you need to report to pretrial release services office in Bartow immediately in person. Thereafter, you need to report by phone twice a week, every week on Tuesdays and Thursdays. Additionally, you're to have no contact with public supermarket stores We have to stay at least 500 feet away from the alleged event location in this case, okay?
Yeah.
All right, thank you, Mr. Miller. Take care. I have one. Unless somebody has something else.
Have a seat right there. Have a seat, Ms. Miller.
All right, are we gonna talk about Angelica Cook?
Give me a second, Judge. Go ahead. I have Nicole Cook is bonded out.
You've been told she's bonded out? She just said Nicole.
Hold on, Judge. Hold on.
Yeah, because we have Angelica Cook and then Nicole Cook, but it's Angelica Cook. And she's on a warrant out of Arkansas, so she should be around.
Yes, ma'am. I have Nicole Cook bonded out.
Yeah, I have her, but we're talking about Angelica Cook.
Exactly. And the building is telling us, the building is still saying they do not have her. So we're still checking.
Okay. You want us to give it a couple minutes or what?
Yes, ma'am.
Okay.
Want me to have them come pick up the mails that are done?
Yeah, they can come get them there. Do we have, I don't have any more inmates.
No, ma'am.
Okay. I'm waiting on a phone call from the building.
Hang on a second, let me get Pilkington. Pilkington, I was told bond. Okay. Thank you. That's fine.
That and Angie. Oh, you don't have Angie? I was in those. Then somebody's going to give her a name. And I'm going to.
Like, what's that about? Then it's like a Muslim or something. I was like, just want to redo that. No, I'm trying to do it, but I'm fine. I can't figure out which one it is. That's all right. I do that every day. So I was like, that was a different one.
Last name, first name, Angelica. That's funny because they just called and said that she wasn't down there. It's in building 3 right now. They were looking for her and they said that she's not there. That's about police officer, but for some reason they're saying that she's not there. All right, thank you.
I called this person. I called this person. Yeah, I know she did it. I called her building. Because she's going to the oh, oh, okay. I called Brian. You called this. Then I think I can get. I got a map.
Mary Central, what's the deal? Have y'all heard anything?
She'll be up in about 5 minutes.
Okay.
And I said, if she don't know her name. And y'all, I don't know. It doesn't sound like a Spanish name to me.
Recording in progress.
Typical sign of someone trying to stabilize themselves, leaning against or leaning against the car.
But this is an hour and a half at least after the accident happened, and the fact that he is leaning, that's what you took as a potential sign of impairment.
That added to everything else, yes.
Okay, well, you obviously saw him walking, right?
Nothing I made note of.
Right, nothing you made note of, because there was nothing in his gait that would suspect that he was impaired, right?
No, not really.
He wasn't swaying, he didn't miss steps or anything like that, he just walked where he was told to walk. And in fact, you didn't note any other signs of impairment with his walk, correct?
I did not note anything, does not mean it wasn't there.
Well, you just told me you're really good at writing reports and you know that you have to put the important stuff in your report. If it's not in your report, it must not have been important, right?
Or I didn't see it.
Okay, you weren't paying attention to that, but you paid attention to the lead.
Because he diverted my attention towards him as I was walking by. And I took notice of him sitting and leaning on the guardrail.
And then you said that you could smell the odor of alcohol from his breath. Is that true?
Yes.
Okay, and you were positioned in the back seat of the vehicle, correct?
Yes, correct.
And you were positioned behind the front passenger where Mr. Roloff was. Correct? So Mr. Roloff, when he's speaking, did not see in your direction, he was directly behind you.
That's what I like. Well, it didn't help with the fact that nobody could find the lady and she was still here.
So here today is that you could smell it coming from his breath.
Yes.
Not about his person, specifically his breath.
Correct. Every
I'm gonna wait. People don't leave me in this one. Here we are, Judge.
All right. We're here for Angelica Cook. Miss Cook? Ma'am, we're not on yet. Oh, hold on. We're trying to get the record back on. One moment. I can get back. Thank you so much. All right, Ms. Cook, I'm sorry for the confusion that you weren't brought over, but I'm glad that you're here now. We're going to do your first appearance hearing, and I just want to let you know that first appearances are for 3 purposes only. I'm going to tell you what the charges are that are filed against you and determine whether there is reasonable grounds to believe a crime's been committed and you're the person who committed the crime. Next, I'm going to ask if you want me to, if you would like a lawyer to represent you. If you've retained a lawyer, please let me know. If not, if you do have a lawyer that you've already retained, I can continue this hearing to another day to allow your attorney the opportunity to be here. If you can't afford an attorney and want an attorney appointed by the court, I can provisionally appoint a public defender to represent you, meaning they could start today, but you would still have to qualify for their services. There is a $50 application fee for applying for the public defender services. And in some instances, the court may require you to pay a reasonable value for the public defender services. The third purpose of our hearing today is for me to review your bond status. Sometimes they're too high, sometimes they're too low. Also know throughout this proceedings, you have the right to remain silent. If you choose not to remain silent, anything you say can be used against you. There's an assistant state attorney in the courtroom with me here today, listening to everything that's being said, and everything you say is being recorded. So please don't say anything about the crime itself. If I have to ask you questions, you may refuse to answer any question that I ask. But please know that you have the right to communicate with your family, friends, and with your attorney throughout this process. And please keep these rights in mind as we go through this process. All right, so Ms. Cook, right now, it looks like you're before us for a fugitive for warrant, a fugitive from justice warrant out of Central Arkansas. And it looks like it's on the charges of forgery, fleeing, possession of controlled substance, criminal mischief. Would you like for me to appoint the public defender to represent you in this case?
Yes.
I provisionally appoint the public defender to represent you in this case, and I have reviewed the arrest report and the warrant confirmation teletype, and I do find probable cause for the charge. But right now, Arkansas has set your status at no bond, so that's the situation right now, okay?
Yeah.
All right, thank you, ma'am. I appreciate your time. Take care.
Okay.
Bye-bye. All right, that should be the last case. Yes, ma'am. We go off record. Thank you, everybody, for your patience.
Okay, Judge.
The non-monetary conditions that do not have any contact with LMK. Your attorney will be able to tell you who that is, if you have any question about who that is. And that you not use or possess any financial transaction card that's not in your name. In regards to the 25 CM 690, there'll be the additional condition that you not have any contact with the co-defendant. Do you have any questions about what those rules are or what they mean? Okay. Let's be clear for a minute. The felony count. We have an address for you, sir, on Gannon. Is that still a good spot to receive your mail? Can you put the Johnson? Yep, you can change that. Do you need that address?
Yes, please.
And what's 19 acres?
You know the zip code? The zip code, please?
I believe it's here 1997.
Thank you.
Judge, I want to be sure here. I may have misspoke here. It looks like count 4 is the only matter regarding the co-defendant. And
Now, 4 is a misdemeanor matter, so there is, he has, I don't see where it's going. I may be wrong here, but I just.
So I see 25 CF 788. That is the misappropriate ID info. That's a class H felony.
Oh. Thank you, Your Honor, my fault.
And for the job center, I have an address, a zip code of 53704.
Thank you.
I believe that, time limits were waived and it's a not guilty plea. I believe that covers everything then. But we are adjourned. I wish you the best.
Next up will be Gilbert, Valdez, for our forwarder. Please open the podium.
Just one moment.
Call it when you're ready.
Translate. That was.
Nope.
Yes.
I'm sorry.
I have to reprint for whatever reason.
Okay. Just one moment, sir.
It's just not. Thank you. Hopefully I'll second it.
This is Dane County versus Gilbert Valdez Jr., 25 FO 491. Can I have appearances, please?
State appearance by ADA Lillian Nelson.
And are you Mr. Valdez? I have what some might consider to be good news. The state has decided to charge this case as an ordinance violation instead of a criminal violation. I expect there will be an offer to resolve your case today. What that means is whether you decide to resolve the case today or not, you'll be unconditionally released from custody for this case. If there's another case holding you, that could affect your release. Is there an offer to resolve?
Yes, it's court costs only.
1450?
1450.
All right. So you have an absolute right to plead not guilty. We can set this case for a status conference. Otherwise, you can enter a guilty or no contest plea to resolve the case today. There'll be a fine in the amount of $114.50. You have 60 days to pay, or you can work with the clerk of courts to set up a payment plan. Would you like to resolve the case today? Good. Okay. And how would you plead? Guilty. Okay. I'll accept your guilty plea. I'll adjudicate you guilty. And you'll receive a fine in the amount of $114.50. We have an address for you on Sunfield Street. Is that still a good spot to receive your mail? Okay, so we will leave that address in there and then we will be adjourned. Thank you. I appreciate this.
Next up will be Marie Smith for a forfeiture. You stand before me.
Let me know when you're ready.
Okay.
Is that all set?
Yep.
Yeah. This is Dane County versus Marie Smith, 25 FO 492. Can I have appearances, please?
State appears by ADA Lillian Nelson.
And are you Mr. Smith?
Yeah.
Good morning. I have what some might consider to be good news. The state has decided to charge this case as an ordinance violation instead of a criminal violation. I expect there will be an offer to resolve this case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases that could affect your release, is there an offer to resolve today?
Yes, it's court costs only.
So what that means is you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea. And I would assess a fine in the amount of $114.50. You'd have 60 days to pay that, and the payment can be arranged through the clerk of courts. So how would you like to plead today?
No contest.
All right, I will accept your no contest plea and adjudicate you guilty. I will assess a fine in the amount of $114.50. And we are, I'm sorry, and I want to check your address. We don't have an address for you. Is there a good spot for you to receive your mail?
Yeah. 615 East Washington.
Okay, so we'll get that changed in our system. Do you need any more information about that? Yeah. And we are adjourned. Thank you. Wish you the best.
Next up will be Jeremy Isbell for forfeiture.
This is Dane County versus Jeremy Isbell, 25 FO 493. Can I have appearances, please?
State appears by ADA Lillian Nelson.
And are you Mr. Isbell? Correct. And did I say your last name correctly?
Isbell, yeah.
Okay. I have what some might consider to be good news. The state has decided to charge this case as an ordinance violation instead of a criminal violation. That means is, whether you decide to resolve the case today or not, you'll be unconditionally released from custody for this case. However, if you have other cases that could affect your release, is there an offer to resolve today?
Court costs only.
All right. So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea. And I would assess you a fine in the amount of $114.50. You would have 60 days to pay, and that payment can be arranged through the clerk of courts, who could also assist you with setting up a payment plan. Would you like to resolve today for that amount?
Correct.
And how will you plead?
No contest.
Okay, I will accept your no contest plea, adjudicate you guilty, and assess you a fine in the amount of $114.50. We have an address for you on Cyan.
No, a homeless basically, so 615, I use 615 East Washington in the beacon.
All right, so we'll get your address changed in our system. And you'll get some information as you walk out on how to pay that fine.
Pay tomorrow.
Okay, cool, perfect. And we are adjourned. Thank you. Wish you the best.
Next up will be Carolina Velazquez. You stand on the yellow X.
This is State of Wisconsin versus Carolina Velazquez, 25 CM 695. Can I have appearances, please?
State appears by ADA Lillian Nelson.
Certified legal intern here, Rayon, appearing with Ms. Velazquez, who appears in person, I believe.
I don't know.
Okay, we don't know if she's eligible for a public defender, but I will represent her for the purposes of today's hearing. I understand the complaint has 2 misdemeanor matters. And as to those charges, we would ask the court, upon finding probable cause by the court, we would ask the court.
I find probable cause of the complaint. What are the state's recommendations for bail?
The state is requesting a signature bond, no contact with Walt E. A ban from the 5600 block of State Road in Marshall, Wisconsin. And a ban from Marcus Palace Cinema, that is the victim's place of work. I would note the victim is specifically requesting the location bans.
There is a PSA filed. It recommends a signature bond. On behalf of Ms. Velazquez.
Yes, we have no objections to the conditions.
But state proposed. I will enter not guilty pleas on Ms. Velazquez's behalf. I'll order the signature bond with the non-monetary conditions that you have no contact with Walt E. That you are banned from the 5600 block of State Road and that you're banned from Marcus Palace Cinemas. Do you understand those conditions?
I do.
And you understand no contact means no contact directly through text or email, not through a third person. No contact means no contact. Very good. Let's see. If I missed it, I'll enter not guilty pleas on your behalf. And then we have an address for you on Thompson Drive. Is that still a good spot to receive your mail on Thompson Drive?
That's correct.
Okay.
1327.
Yep. So we will keep that address and then we are adjourned. Thank you. I wish you the best.
Next up will be Latoya Warfield. You stand on the yellow. Actually, before.
This is Dane County versus Latoya Warfield, 25 FO 496. Can I have appearances, please?
State appears by ADA Lillian Nelson.
And are you Ms. Warfield?
Yes.
I have what some might consider to be good news. The state has decided to charge this case as an ordinance violation instead of as a criminal violation. I expect there will be an offer to resolve the case today. What that means is whether you decide to resolve today or not, you'll be unconditionally released from custody for this case. However, if you have other cases that could affect your release, is there an offer to resolve?
Yes, it's court costs only.
So you have an absolute right to plead not guilty, and we can set this case for further proceedings. Otherwise, you can enter a no contest or guilty plea, and I would assess you a fine in the amount of $114.50. Payment on that amount can be arranged through the clerk of courts, and you'd have 60 days to pay, or you can work with the clerk of courts to set up a payment plan. Would you like to resolve today for that amount?
Yes, no.
So if you enter a no contest or guilty plea, I would fine you $114.50. Otherwise, if you enter a not guilty plea, I would set this case.
Okay, so Judge, this motion is on for a motion to depose the officer in this case. To begin with. Let me scroll. So to begin with the consequences that he is facing, he's charged with 2 first-degree misdemeanors, 1 count of aiding a runaway minor, and another count of contributing to the delinquency of a minor. Both first-degree misdemeanors punishable by up to 364 days, 2 years in jail for this. Additionally, as far as I see, he does not have any local priors. I don't know if he has any national priors, so this would be his first conviction. So there are great consequences to this individual. Secondly, the complexity of the issues. First and foremost, this charge does involve a minor, and that in itself does make this type of charge very complex. The officer in this case had multiple interactions with Mr. Rodriguez, and also had interactions with the minor child in this case. There's no body-worn camera that was turned over, so it's defense's position that we don't have much to investigate, such as any potential motions to suppress or any other constitutional motions. We just have what the officer wrote in the arrest form, which isn't really much. It doesn't really detail the interactions that he had with Mr. Rodriguez, as well as the alleged victim, which is a minor in this case. And additionally, on Thursday, when this case was addressed the first time, the court also mentioned that once reading the charges, the court mentioned that questioned if this was a misdemeanor charge because of the complexity. You were surprised that it wasn't a felony. And I think that in itself shows that this is a complex issue. Next, going to the complexity of the witness's testimony. This deposition of the officer can open the door to further investigation of this case. We don't really have much with the arrest form. All we have is the arrest form. No body-worn camera. There are multiple interactions that the officer had with this individual, and we just don't really have much to go on. And lastly, other opportunities to discover the information. There's no body-worn camera. Anything that the officer observed, it's not discoverable in other ways. We just have whatever he will testify to in trial, and there isn't much for the defense to do other than that. So we would be asking for a deposition for the officer in this case.
Response from the state?
Your Honor, cases existed prior to body-worn camera, and misdemeanor cases did not have depositions granted liberally before the existence of such. Again, there has to be good cause shown in a misdemeanor case. All that the defense has proffered is that this might be complicated.
What exactly are depositions? What do you mean by deposition?
Andy, relax. The deposition is just an
Okay, you know, folks,
what's going on in
I
the case.
cannot have
Please relax.
interruptions like this. If not, I'm gonna have to remove you folks.
Your Honor, misdemeanors are presumed to not be complex. Although this case is maybe not a charge that's commonly seen, it's actually not too complicated of a charge. We've tendered over the OIR as well as the A form. And basically anything that the officer would testify to would be what's in the incident report.
Miserable piece of shit. What the fuck are you saying? What the fuck is the deposition?
Okay, he's removed. Yeah, removed.
I'm removing the judge. Oh, okay, you got it.
Thank you, gentlemen.
Okay.
Anything that
Mr. Torres, I removed your brother.
I
No
have been Baker
interruptions.
acted. I have been Baker acted. I have rights in this country. I am not illegal. I am not doing anything to.
Okay.
You know, the
Continue.
nature of what the officers will testify to will be no different than what's been tendered over in the office incident report. Simply because there isn't body-worn camera is not good enough reason to rise to the level of good cause to take a deposition in a misdemeanor case like this. furthermore, the officer's involvement with the case itself is, I mean, a lot of what it seems like the defense counsel would like to get out from a deposition would be seemingly, I'm assuming, would be hearsay type of statements that the victim gave to an officer. Really, it seems like the defense would like a deposition of the minor victim in this case, but they know that that wouldn't happen. So it seems like they're trying to maybe get some backdoor statements from the victim through the officer's deposition. And that seems like something that the court should not allow, given the nature of the charge. And as far as the consequences argument, which is the first part, yes, there's maximum exposure for an M1, which this charge is, but that's not what the state is seeking at trial. We're not.
Do you have
not
an offer in
seeking-
this case?
Yes, Your Honor. Your Honor, my apologies. I'm not able to find it right now. However, again, it's not the maximum exposure. We're not seeking 364 days in the Dade County Jail. I will find, I had it somewhere. It's just not populating in the case.
I just don't see any notes and I usually ask,
Right.
so I don't think that an offer has been.
It might not have
disclosed
put on the record. I saw notes about an offer before.
Have you received an offer?
As far as I see in my notes now, I don't have an offer, but I'll let you finish before I respond.
Again, the state's not seeking maximum exposure in this case. And that's basically it. Sorry, go ahead.
So if I may, Judge, first and foremost, just because the state is not seeking the maximum in this case does not mean that he's not facing the maximum if he were to lose at trial. Secondly, if we wanted to depose the minor child, we would have filed a motion to depose the minor. We did not. We're asking to depose the officer. Now,
What's not in the discovery that you're looking for?
So first, I also have a motion to compel. I don't have any OIRs, so I wanted to place that on the record.
I have an email sent. Let me see.
I had one on hand that I don't know if I hand delivered it to the court, but I did give one to the state on Thursday, which is supposed to be addressed today. Judge, it's our position that first, we do believe that this is complex, right? The officer had multiple interactions with this individual. We don't know if statements were elicited without Miranda warnings. We don't know what happened when he came. And yes, I do understand that there are other ways to, I do understand that some cases don't have body worn camera, but based on what I have, I don't see anything that I can work with.
What is it that you have?
I have an arrest warrant.
Your Honor, I see on October 28th, it appears ASA Sonia Viola sent an email to Misty's service that included the offense incident report.
Okay, are there any
And I'm looking
pictures
at
in
a
this
copy.
case?
Sorry?
Do they have any pictures as
There are
evidence?
no pictures that we have in our file, and there are no body worn camera links that we have in our file either.
Your Honor, I
And Judge,
apologize for interrupting.
I-
Could the interpreter leave?
No, yes, I don't think we have does this gentleman speak English, the one in the back?
He's free to, you're free to go.
Yes, I think we're gonna excuse you. Thank you for
Okay.
speaking up, Mr. Marte.
Okay, no, I wanted to interrupt.
Okay.
These
All right,
two
thank
attorneys
you.
are doing a bang up job.
All
Bye-bye.
right.
So if I may continue, Judge. Right, so if we wanted to seek a deposition of the minor child, you had filed a motion. to
Okay,
depose
so
the minor child.
paragraph 3 says, you list a whole host of things that says special victims bureau, photos included in OIR, photos of defendant arrest and flyer. What is all that about?
Oh, that's my motion.
It's a motion to compel, yes. Where did you
So-
get all that information?
From the arrest warrant.
So that's all items you should have received from the state.
Yes, that I don't have yet.
Where are all those items state?
Your Honor, we would stipulate to a motion to compel being sent to the department because we don't have many of those either. We did send the offense incident report, though. That was sent on October 28th.
Okay, I want you to look at paragraph 3 of their motion to compel and tell me what you've turned over.
So the photos in the OIR and the photos of the defendant in the arrest flyer. And I believe the special victim bureau, we don't have that either. So I mean, again, yeah, we stipulate to a motion to compel, so we could send it to the department and make it easier for both sides.
Okay, the motion to compel at this time is granted. 20 days to produce.
Judge, I thought.
And
Mr.
I'm gonna
Davis asked for
reserve
Judge.
ruling on your motion to take a deposition at this time.
Okay, may I finish laying the record for the motion?
Right.
Proposed, please?
Go ahead.
So
Thank-
right now, it's defense's position that a motion to depose would be appropriate in this case. We believe that just the involvement of a minor child, the many interactions that this officer had with this individual, the allegations that are being, the allegations by the state, we believe a motion to depose would be appropriate in this case. We cannot effectively represent Mr. Rodriguez at this point because I don't know if there are motions to suppress here. I don't know if there are other motions, constitutional motions that can be filed without getting the officer side of the story aside of what's in this A form. And honestly, based off of what I've seen so far, it doesn't seem like there's much. Like there are multiple dates that this officer interacted with this individual, as well as the AV. I don't know if the alleged victim gave a statement to the officer. I don't know. And this isn't to then open the door to a deposition for the minor, but we just need to investigate. And I can't do much with what I have, so.
Oh, yeah, of course.
Okay. I'm gonna reserve ruling on the motion to take a deposition. Granting the motion to compel, you have 20 days.
Yes, Your Honor.
I'm gonna reset this for status on April 22nd
Thank you.
at 11 a.m. and readdress this motion to depose, see what they produce.
Yes, Your Honor. I think once further discovery has been tendered over to the defense. we might be
If
able
it's
to
not
engage.
tendered, I'm gonna grant the motion so that you know.
Understood.
Okay.
We should be able to get it.
All right.
April 22nd.
At 11 a.m.
Thank you, Judge.
Okay, how about Alexander Rivera? What do we say about this one?
Oh. Yes, Judge. This was also for a stand your ground.
This is what we're waiting for now?
Oh, okay.
No.
What's going on with this case?
So actually,
This is on
sorry.
24/024/419?
Yes.
Yes.
Okay,
Yes.
State has an announcement by victim's request as to case M24024419. The state announces a no cross.
very good. Okay, so we're ready to start that other case. I think, oh, Mr. Lorenzo's. I need an answer from the state on Mr. Lorenzo.
Hello?
Yes,
I'm right here.
Lorenzo?
this is on the matter of Osvaldo Martinez. He was an employee of Mr. Lorenzo. Mr. Martinez was driving a company car when he was caught with a DUI. And he was gonna show you proof that he owns a vehicle because he doesn't want it to be the interlock to attach to the vehicle.
That's fine. Wouldn't
He's gonna show us some proof that he owns the vehicle.
But wouldn't the defendant have to be present here for us to alter any conditions of the defendant's probation?
It's not altering it. I would just vacate the order.
You would vacate the order for the ignition interlock?
Right, so you want to see the proof? Okay, you have to unmute, let me see here.
You see it?
Give me a second.
But we would want.
Okay, so this is a 2008 Chevy truck. In your name, can you,
2006 Chevy.
2006, I gotta get new glasses. Okay, roll it to the other side so I can see the expiration, Mr. Lorenzo.
Can you see it there?
1/26 of 26, yes. Let's see, does it tell me what the make and model was of where Mr. Martinez was caught? Let me look at the A form.
Your Honor,
Yes,
if the court's inclined to vacate the.
I just want to make sure you verify the ownership.
Yes, can I have the case number one more time?
It is A0NL6KE.
I mean, then we would request in the alternative, the remote breath be instated.
All right, so that's gonna complicate things.
Chevrolet
And it seems like he just took this plea
in December.
in December. No, January, I have January 31st. So this just happened.
Yes, Your Honor.
All right,
He has until June, I believe, to complete the conditions.
all right, but we're gonna have to call in the lawyer
Right.
to do this.
Yes.
Mr. Lorenzo, I hate to do this to you because you've been bumped around. But I'm gonna delay this till tomorrow and get the lawyer in here.
Okay.
And explain to him what's happening and see how this can be resolved, okay?
Okay.
All
So tomorrow at the same time?
Tomorrow, I would, yes, tomorrow come in the, let me see, tomorrow, I would say about, want to say about 2:15?
2:15?
Yes,
Yes,
and we'll
ma'am.
address you, okay?
Okay. Thank you.
All right, you're very welcome,
Okay.
okay.
Bye-bye.
What did we say about Wilson from 145? Was he a non-show?
Leah Wilson?
Yes.
I didn't see anybody with that name on the platform.
Okay, so this is a no ruling.
She was there, but.
She was there?
Yeah, she's still there. Amiga Wilson.
Okay, Miss Wilson? Miss Wilson? What relief? Oh, she has a bench warrant for $1,500. Miss Wilson, can you address the court, please? Okay, I don't see her. Where do you see her?
She dropped off just now.
Okay. And who's James on the platform? And how about Alex Clayman?
That's an assistant public defender, Your Honor.
Okay,
Additionally, if we can recall Mr. Ekakor's case.
I think that's what we're gonna do now, right?
Oh, perfect,
That's what's
yes.
left. Okay. 301, okay. Christopher Ekakoro.
Yeah, I'm
Case
here.
number AGL3WIE.
I'm here.
Okay, we're gonna call your case. Appearances from the attorneys for each side.
Yes, Your Honor, ASA Colonel Mead on behalf of the state, and we would be having our CLI intern, Alex Rico Gonzalez, handling the case as well.
Okay, Mr. Gonzalez. All right, so state, call your first witness. I mean, no, I'm sorry. Let me pause. Defense, state your appearances, please.
Good afternoon, Your Honor. Assistant Public Defender Christine Loiza for the record.
Okay, anyone else or
And
just,
Assistant Public Defender Courtney Dash.
okay,
And Your Honor, I did want to briefly mention to the court that I did speak with Mr. Ekakor, and he advised that he would be waiving his presence for this
okay.
motion.
He doesn't want to even watch on Zoom.
No, Your Honor.
Okay, so, okay, folks, so I think he already left.
No, he is still there, Your Honor.
All right, so if you're not gonna watch it, I'm gonna turn it off.
Okay.
Okay, all right,
I'll see you later.
like who?
Like Kalia, she's back.
Okay, Miss Wilson,
She's joining. There we go. We should be able to hear you.
okay, Miss Wilson,
Hello.
hi, you had a case on the calendar for 145.
Yes.
I issued a bench warrant, for your failure to be here on November 18 of 24. You failed to appear to a second arraignment. You are charged with, reckless driving, causing property damage, personal injury. It says ABC1 wreck. What is that?
I believe that was from a car accident a while back. I assumed that it was getting taken care of. I had other court dates that I had went to, but I ended up moving away from my present address for temporarily due to a job, but now I'm back. But I wasn't being informed that I was having court hearings sent to the house. So that was on my behalf of communication with my household.
Okay, what's the state's offer?
Your Honor, just to lay the record, the state would be objecting to setting aside the bench warrant, and the offer is adjudication, court cost, $500 fine, and high-risk traffic score.
Okay, would you like to consider that offer? Do you
So
need
the off-
fingerprints? Do you need fingerprints?
For a reckless driving, I do not believe so. Actually, I apologize, Your Honor. Yes, being as it's an adjudication.
Okay, so you said an adjudication
Yes, Your Honor. He has a prior right.
and court costs?
Cost $500 fine and prior traffic school.
And they need fingerprints. If you want to take that offer, I can give you a date to come in and take the offer.
Okay, and if I was to take this offer, the only thing that I would have to do is to pay the $500 and go to a traffic school.
High school, yes, high traffic,
Risk.
high risk traffic school, yes.
Is this assigned to me or would I have to sign up for myself?
Well, it'll be court ordered and then you would have to go to that traffic school to get it done.
Okay, another question,
Yes,
because would it be set to the side until I finish that? The warrant, will it be set to the side until I finish that? What would be the case?
well, what I can do is I can set aside the warrant today, give you a date to come in. So you can take this plea and we can take your fingerprints. If you fail to come in the next scheduled date, I'll reissue that bench warrant.
Because no, I plan on coming in. It's just due to the fact of I'm trying to get this job, but I won't be able to get another job until the warrant is set to the side, or at least I they said get some deposition papers or something like that.
Disposition.
Yes, disposition papers.
Right, so the earlier you come in, the sooner you'll have that disposition document.
Mm-hmm.
So, I can grant your motion and have you come in for plea next week. Does that work for you?
Next week, and that's the earliest date.
Or if you want to come in one day this week, I can do that too.
Yes, one day this week would be perfect.
Okay, you want to come in on Thursday
Yes, that's fine.
at 11 a.m.?
Yes. Would I be able to get like an email with all this information?
No, I'm going to give it to you now. There's not enough time for you to receive it in the mail. So I'm going to give you the information now, okay?
Okay, one moment. Let me get something to write this down. Okay, yes, what is it?
It's 1351 Northwest 12th Street.
Northeast?
Northwest
Oh, Northwest.
12th Street,
Mm-hmm.
Miami, Florida. 33125. And that's the Richard E. Gersten building, where the courthouse that's next to the jail. And my courtroom is 6-6. Okay, so we'll see you Thursday at 11 o'clock, okay?
Okay, is there anything that I would need to come with?
Do you have just your ID? Okay,
Okay, thank
we'll
you.
see you Thursday.
Okay, thank you.
Okay, folks, if there's anyone else that you see, we can address them. I'm gonna shut down Zoom. All right. James, the person James, if you want to address the court, this is the time. If not, I'm going to disable Zoom.
He's there.
Yes. Okay, so you're just observing? Okay, so for these in-court evidentiary hearings, I disabled Zoom, so you're welcome to join us tomorrow. We start at 9:45 and you can watch all morning, okay? Okay. Thank you, Mr. James. All right. All right, let me just close this out.
and somebody says, yeah, I think this happened more likely than not. You see people coming through